them for listing for orders on Friday if it pleases the
What
Lordship.
orders?
We need a stay, Lordship, because the execution.
MSc appeal.
Yes, Lordship.
There was no stay.
No. Appeal was admitted. On that day, we found that the stay was not granted. So we need the stay petition is there, Lordship. On
How much
Friday.
is the awarded amount?
I exactly don't remember, Lordship, but we can deposit
No, we'll
it
have it on the yes, we'll have it.
on Friday. Highly obliged.
May it please your lordship, my lord, as a last resort, my lord, I am mentioning for listing a matter arising out of matrimonial dispute in the family court, my lord. This matter is
Press matter.
yes, ma'am. Fresh.
When do you want?
Tomorrow, my lord.
Urgency is there.
Urgency is there, my lord. Deeply obliged.
My lord, I beg to mention for listing of the matter, my lord. Appeal is admitted, my lord. Second appeal is admitted, my lord. IA, my lord, we want to place, my lord.
I for stay.
For stay, my lord. On Monday, my lord.
My pleasure, Lordship. I beg to mention listing of IA 4062 of the 2019
For
orders matter on Friday, Lordship.
no, I for what?
IA for leave application, Lordship.
Leave.
Leave application. It was partly heard on 21st of this month. Last
21st
Friday it
of-
was heard. We delay. It was disposed of, but this was not disposed of. This was partly heard. So matter may come on Friday.
This court
Lordship.
has had this matter.
No.
Some other.
It is some other matters was there. Delay was there. Your Lordship disposed of delay matter. With this case, one miscase also there. So that was also partly
On
heard.
Friday,
On Friday,
Monday.
Monday.
My lord, also, my lord, praying for listing of this matter for order. My lord, actually, the second appeal was dismissed, my lord. Then on the ground of abridgment, then they file a petition, but that was also withdrawn, my lord, for filing afresh. So they file a petition. We also file the objection there to my lord. My only predicament is time for the respondent. One of the my respondent is very old. She is about 85 years old, my lord. So this matter may fix when lordship may pass an order whether it's
Yes, next week.
any date, my lord.
Put a date in the next week. No.
May I please have that? My lord, sir, I document item number 15.
1-5.
One,
Yes.
I am praying for adjournment, my lord.
Here for whom?
I am for the respondent.
Inform the other side.
Yes, ma'am.
Mr. Das. Oh, on a prayer made on behalf of the respondent. Matter stands adjourned by 1 week.
Next Wednesday.
Adjourned to be listed on Wednesday next date. Huh?
Interim order, your lordship.
Interim order passed earlier to continue till the next day. Yes.
May I please, your lordship? Therefore, listing a transfer petition, lordship.
Press matter.
No, lordship. Parties are already ready to negotiate, lordship. So, your lordship, matter may be referred to
Mediation.
mediation, your lordship.
Have you done Friday?
Lordship, next week, lordship. Lordship, another pair for listing a MSc appeal. We are the claimant, lordship, and by virtue of stay order, they are enjoying the stay. So, it may be come up also next week. If you
Lordship, with the consent of the opposite party, I beg to mention item number 21.
21, yes.
Yes, Lordship. Matter may kindly be adjourned for the day,
You're
Lordship,
for whom?
for the petitioner.
For the petitioner.
Yes, Lordship.
When do you want? Next week?
Next week, Lordship.
On a prayer made on behalf of the petitioner. This after a week. Yes.
Next Lordship.
May I please, for listing, my lord, CRPC IO matter.
Press matter.
Yes, my lord.
When did you fight?
Yesterday, my lord,
When do you want?
on Friday. Hello.
May I please, your lordship? I beg to mention for listing of a CRP IO, lordship, on Friday.
Press matter.
Fresh matter, your lordship.
Please, your lordship. Lordship, I would like to mention item number 52 of today's list.
52.
52.
Yes.
Lordship, there is a concern from the other side. There is a compromise talk between the parties, your lordship.
The hearing matter was 17.
Yes, your lordship. My lord, the talks are in advance. That is why we are mentioning it.
You're for whom?
For the defendant, your lordship. Respond.
In the
A.K. Mohandas.
appeal, you are for the respondent.
Yes, your lordship.
I'm for the respondent, your lordship.
She is also there.
I'm for the respondent, your lordship.
No,
So
no, you're for the petitioner.
Uh,
Who is for the appellant?
I am for the appellant, your lordship.
Now tell us, you're saying a respondent. You're it, Mr. Mahanta.
Yes, your lordship.
Okay. This court has been apprised. Yeah, madam, is there a talk of compromise going?
yes, your lordship. We have
This
been
court has been
instructed.
apprised. No, don't write. The learned counsel for the parties have jointly apprised this court that there is a talk of compromise going on. And therefore, a prayer for adjournment has been made. So, Para, considering the same, matter still adjourned to be listed after 3 weeks.
3 weeks, your lordship.
17 matter, after 3 weeks, they are going to adjourn.
Lordship.
Okay. Madam,
Lordship, I like to mention MSC appeal number 40/2021. It's a fresh matter. If possible, my lord, it is short for the posting on 27/8/2023.
27,
28/7.
28 on Friday. Here for the appellant. Have it on Monday. 31st.
Please, your lordship. With the consent of the other side, I beg to mention item number 34, lordship.
Yes.
Lordship, London Senior Counsel, Mr. BC Das is unavailable today, lordship. Can this matter be taken up after a week, lordship?
Matter of which year, 21.
21, lordship.
Inform the other side.
Yes,
It is submitted that BC, the senior counsel, has some personal difficulties. At least after a week.
lordship,
Yes.
interim order is there, lordship. That may be extended.
Anyway, list on Friday next, if Friday, next Friday, this, if Friday. That no, 4th of August. 4th August, interim order passed at a
Oblige, lordship.
May I please, your lordship. Also, I beg to mention for listing the matter tomorrow, lordship, CRP. It's very urgent. In DRT case one, surface proceeding is going on.
Fresh matter.
Yes, fresh matter, lordship.
What is the urgency?
Urgency is that in lordship, in this case, there is a successful bidder and a bank. There was a transaction. I was the petitioner. My house has been bidded, and I asked some document from the bank and filed a petition on before the DRT court. But that petition has been rejected, lordship. And tomorrow is date for hearing, lordship. Lordship, maybe come for tomorrow. It's very urgent. I need that document for hearing purpose also.
The OA has come to an end.
No,
This is
not
the
in
execution procedure.
it's OA and service both are in pending, lordship. In both are in the hearing.
Then why is it execution? Why?
Yes, lordship.
Where is the successful question of successful bid?
Your lordship, when before surface proceeding, there was that e-auction bidder that bank has been completed. And when I have been party, I have filed a petition before the court that I need that document before the successful bidder and the bank. That petition has been rejected by the court, lordship. Lordship may come tomorrow, lordship.
We don't find any urgency.
Lordship, it's very urgency, lordship. Yet, if the hearing has been completed, your lordship, I would get a chance,
And
lordship.
that for CRP. Okay, we'll try. Let's say on Friday.
Friday, lordship.
Friday.
May I please, your lordship, I beg to mention item number 30 of the daily list.
Yes.
Lordship, my senior is currently unavailable due to ill health.
Who is your senior? Sattar?
Yes, your lord.
Your imtiaz?
Yes, your lord.
Will after a week,
Yes, your lord.
G imtiaz learned council submit that is senior 3A Sattar is not well and therefore he plays for some time. Put up. List after a week.
Highly obliged. Your Lord.
Lordship,
may
kindly
please-
list the matter
may
for the
please-
withdrawal on tomorrow.
Hmm?
Kindly list the matter for the withdrawal on tomorrow.
Withdrawal. We haven't done Friday.
The matter already been settled by the parties.
Understood. Friday, not tomorrow. Friday. Tomorrow we have got many matters. Hearing. Friday. Yes.
May please, lordship, my item number is 3, lordship.
Hmm.
There are some defects in the petition. I want to withdraw it for with the liberty to file it. This is CRP, civil revision petition.
You're appearing for whom?
Item number 3, I pay in petitioner, lordship.
How can you appear? Are you a counsel?
Oh, I'm attorney holder, lordship. That's
Attorney
why
holder can appear as a counsel.
I'll request for permission of the court, lordship.
Will not allow unless it's your own case.
She's
There is a procedure in the court.
she's my mother, lordship. She is very
Mother
good.
has to come. Mother has to engage a lawyer. You are not a lawyer. You have a license of the bar.
But she cannot properly sign it. This is the
That's
matter.
not
lordship.
required. He's a lawyer. You cannot engage a lawyer. Illiterate person cannot engage a lawyer.
Oh, okay, lordship. I'm withdrawing because I filed it
See,
already.
you can appear in your own case. You cannot represent anybody.
Okay, lordship. That is there. I'm
Otherwise,
withdrawing, lordship, withdrawing for liberty to file it with the council actually.
Oh,
And my lord, item number 4 is connected to item, my lord, that may be adjourned for a week, my lord.
You are the counsel there.
I'm counseling.
Same petitioner.
Same, Lord.
Same petition means.
Same petitioner.
Same petitioner.
Three. What is your name?
Ghanshyam plus Dhiman, Lord.
G.
Ghanshyam, GD Dhiman, Lordship.
G.D. Dhimal.
Yes, Lord.
Three. G.D. Dhimal. Appearing in person. Has appeared in person and has submitted that he has been authorized by the petitioner to appear on her behalf.
Sorry, I made a partner from here.
The issue,
Sorry.
whether such authorization itself would be sufficient to enable a person without a license of the bar council is itself doubtful. Be that as it may, Sri Dhimal has paid for a leave to withdraw this petition with the liberty to file afresh.
Lord.
Petition according to also heard MS A and Leonard CGC. Para. Petition is accordingly dismissed on withdrawal with liberty as paid for.
My lord,
Only in three.
registry will be directed to return back the certified copy so that he can.
You want the certified copy?
Lord.
The certified copy filed along with this petition may accordingly be returned to the party.
Lord.
Only in three, huh? Four you are pressing today.
My lord, 1 week, my lord.
Four, on the prayer of three. As Sahu, done it counsel for the petition at least after a week.
Because my lord, issue is same, that is.
Also heard a guy.
My case will be listed for admission, my lord, because
Yes,
notice has already been issued.
Okay, list for admission. No, as a country. Yes, Sahu, Learned counsel for the petitioner submit that the matter has already been, and that notice has already been issued in this matter. And the same should come up for admission. Also heard, MS and Leonard This for admission after a week. Yes.
Here, my lord, I need some time, my lord. As per order dated, my lord, 10 to 2023, my lord. My lord, I have directed to file a detailed report, my lord.
Yes.
It has yet to complete, my lord.
Yes.
My lord.
PK Learned Training Council, Elementary Education Department. Praise for time to submit the report. Also heard Sri Jayad Ahmad, Learned Counsel for the petitioners.
I'm appearing for respondent number 3.
And MSP Das for the respondent number 3. Take care. Please take care. Standing State Council and PDA for respondent. How much that?
August 23, my lord.
As paid for list on 23rd of August.
My lord. Hello. Obliged, my
23rd. 23rd? 23rd, Wednesday.
May it please your lordship. Lordship, this is a transfer petition seeking transfer from a money suit from a senior civil judge Dimapur to my lord, your lordship in the Kamrup
My lord.
Road in the Karimganj, my lordship.
My lord, I'm not served a copy. My name is not shown also. I'm not served a copy, my lord.
I'll serve my lord today itself. She's appearing for government of Nagaland.
Yes.
On
Hello.
Friday with her,
Today only I will serve.
she needs to have some.
No, I don't have a copy.
My lord,
It's not served.
this is the money suit between the private party, my lordship. Government is a proforma party. I'll give the copy, my lord,
Tomorrow then,
tomorrow. My lord.
tomorrow. Madam, tomorrow?
Lord.
I'm a Sikh council, Plan Standing Council. Plan State Council for Nagaland, submit that copy has not been served in spite of the fact that state of Nagaland is the respondent upon. What is your name?
D. Hussain, my lord.
Treaty with it, then council undertakes to serve a copy
I'll
during the course of the day. Please for motion tomorrow.
highly obliged.
Pledge.
May I please? My lord, we have come against the order of amendment of the plain bill. My lord, this case was instituted in the year 2011. my lord. And my lord, after several filing this case, my lord, ultimately, my lord, suit has concluded and my lord.
You are for the defendant.
Defendant, my lord. And 15 witnesses of our examination. There they examined 7 witnesses, fixed for argument, my lord. They took time. We argued the case. Next day it was fixed for argument of the plaintiff. On that day, my lord, they have again filed an amendment petition. Which
After conclusion of argument,
our argument, they have not given. My lord, argued the case.
what is the stage of amendment?
My lord, amendment was granted, my lord.
No, as per the law, when can amendment be done?
Order 6, Rule 17. my lord.
17 years.
Yes, my lord.
When can it be done?
My lord,
Is there any time fix?
my lord,
Is there any time fix?
before the, not after commencement of the trial, my lord. It is not only commencement, it is near about conclusion, my lord.
You want to contend that it is in violation of the proviso.
Proviso also, my lord, and it will sense the basic structure of the case. Initially they have instituted for right declaration of title, cancellation of document, and confirmation of position, my lord. And during the proceeding, my lord, they have filed several petitions for.
Now, what is the amendment sought for?
They are sought for recovery of position, my lord, regarding particular area, my lord.
This is a different prayer.
Yes, my lord. Sense the basic structure, my lord.
Where is the order?
Order is, my lord, at page 92. On the basis of one Supreme Court order, my lord, which has guideline regarding several points. He has took only point of limitation because amendment sought for the period of 2012, my lord, occurred 2012, my lord, he has filed amendment petition 2023. And all the facts are available earlier also. They have filed in earlier petition. That facts are also available in the.
Where is the operative part or the
Yes,
part of the order which you were trying to refer?
my lord, before that I am come to the page number 104. The order passed on 16/9/2012. my lord.
Yes.
Both these sides are represented. Plaintiff has filed a petition number so and so, praying for amendment of plain, start miss case number in month. From on 16/9/2012, they have filed this petition, my lord. And prior to that, my lord, order to be order to execute argument petition 77. And order reflect, my lord, in 77, my lord. Page 77, my lord. Both the parties are duly represented. Today is fixed for argument. Heard the argument advanced by the counsel for the defendant side. The learned counsel for the plaintiff side has filed a petition, by petition number so and so, praying for another date for argument. Heard and allowed. Plaintiff is strictly directed to make his side of argument on the next page, my lord, 77. Plaintiff is strictly
Just a minute. Page 77.
77, my lord.
That was on 12/8.
12 minutes. Prior to that also, they took time, we also took time, my lord.
Today is to heard the argument. Advanced by the defendant side. I paid you. And what happened on 25/8? It was on leave. 25/8, PO was on leave. On 16/9, they filed the amendment.
Yes. My lord, the amendment sought for was for the year 2012. Prior to that also, after that also, my lord, they have filed one amendment petition. In that amendment petition was allowed. In that petition also, they have not disclosed the text of the disposition or everything, my lord. Because it is relating to the 2012, my lord. They have filed petition, earlier petition.
What is the suit for initiated?
Initially, my lord, declaration of title, cancellation of our sale deed, and for confirmation of possession. By subsequent amendment allowed by the court, that was, my lord, for recovery of possession or particular Schedule E. Now again, they have raised the same prayer, my lord,
Now it's for recovery of possession.
recovery of possession. The facts available in the record itself also, my lord, prior to amendment, filing the amendment, my lord. And during the pendency, they have filed 2 violation petition. There is an injunction order, my lord. That violation order also rejected because they could not prove. So if any violation was made, my lord, then also earlier of the petition.
Three years declared and senior counsel assisted by Sri R. Islam for the petitioners. The petitioners, for the petitioners who are the defendant in the connected title suit.
That's it.
The inside petition has been filed under Article 227 of the Constitution of India, right, with Section 151 and 115 of the CPC against an order dated
21/6/2023.
29,
21/6/2023.
2023, whereby the petition bearing number 1570 of 2022 filed under Order 6,
Rule 7.
Rule 17 of the CPC for amendment of the plain has been allowed. The senior counsel for the petitioners has submitted that the title suit is of the year 2011, which was filed for declaration of right, title, interest, right title and interest, comma, cancellation of sale deed, and confirmation of possession. And the state suit has been contested and was at the stage of hearing of arguments. The attention of this court has also been drawn to the order dated 12/8/2022 passed by the learned Musif number 1 Dhubri in the state proceeding, from which it appears that the defendant's argument was already over and the matter was adjourned for the argument on behalf of the plaintiff. Thereafter, on the next date, that is 16/9/2022, the amendment petition has been filed. By referring to the provision of Order 6, Rule 17 of the CPC, relating to amendment of pleading, the learned senior counsel has submitted that the state order is in violation of the statutory provision. On fact, he submits that the amendment allowed, that the proposed amendment allowed, which has been allowed, would change the nature and character of the school. And it is a matter of record that on an earlier occasion, an amendment was already sought for and allowed, in which the present facts were not brought to the notice of the court. It is also submitted that the petition filed by the plaintiff alleging violation of the injunction granted to the suit have also been rejected. Para is to notice returnable by 4 weeks. That step for service of notice upon the respondent be taken by registered post office AD, step within 2 days. Para, the learned senior counsel praised for an interim order. This court has noticed that the suit, which is of the year 2011, was at the final stage of argument, and it prior appears that the petition filed for amendment may not be in conformity with the statutory provision, and also appears to be one which would change the nature and character of the suit. At the same time, this court cannot lose sight of the fact that the suit is of the year 2011 and would require an expeditious disposal. Therefore, balancing the equities, while further proceedings entitled to 263 of 2011 pending in the court of the Munsif number 1 Dhubri is stayed till the returnable date, it is observed that on the appearance of the parties, an endeavor will be made to dispose of this petition. Next step immediate. Yes, Mr. Roy.
May I please, Lordship? My lord, the petitioner, he was a tenant in respect of the Assam type house and running a restaurant near Ullubari Charal in the name of Borua's Inn. And the predecessor interest of the present respondent was the landlord, Lordship. So the predecessor interest of the respondent, one intended to construct RCC building by demolishing the old Assam type houses, to which the petitioner has agreed, Lordship. And accordingly, Lordship, before that, Lordship, 2 suits were filed, one by the predecessor interest of the respondent for the ejectment of the present petitioner, and the present petitioner also filed a title suit that he should not be dispossessed forcibly and illegally. Both the suits were compromised between the parties amicably, and the compromise decree was passed by the learned trial court, Lordship, by which it was mainly agreed that after construction of the RCC building, the RCC room, Lordship, measuring 345 square feet, along with the latrine, bathroom, water tank, will be provided by the predecessor interest of the respondent. And in case of failure to do so, Lordship, the within the 7 months period, Lordship, the predecessor in the respondent should be bound to pay compensation of rupees 500 per day. Lordship. So the after reconstruction of the RCC building, only 319 square feet position was delivered by the predecessor interest of the respondent to the present petitioner Lordship. And there was a shortage of 26 square feet. And the other terms and conditions were also not complied. No latrine tank, water tank was constructed. Drain was not constructed. 3 kilowatt electricity connection was not taken by the landlord Lordship. Accordingly, a title execution was filed, Lordship. In the title execution, Lordship, the which is that title execution case, Lordship, is of year 2017. Many petitions were filed, but and the petitioner in the petitions claimed compensation at the rate of rupees 500 and other to fulfill the other terms and conditions. But the respondent did not comply, Lordship. Then, Lordship, the learned executing court, by the impugned order, passed a strange order modifying the decree, which power does not vest with the executing court. So, at Lordship, the annexure number 14, page.
Which part of this order?
This part or the last part, Lordship.
Internal page 13.
Page.
Internal page 13 over.
Page, Lordship, the order starts from page 103, annexure 14. Operative part, Lordship, may please to come to the
Internal page 13 over.
Lordship.
12. Internal page 12 of the order.
Yes, yes. But the impugned order is, Lordship, page 103.
Understood. What is the internal page of the order?
Internal page of the order, Lordship.
12. Okay, what is the running page? Tell us the running page, no problem.
Yes.
Tell us the running page, no problem. We have the order.
I mean, operative part.
Operative part, Lordship, starts from page 115.
115.
Your Honor, please to come to page 114, last part.
Yes, sir.
114.
Yes.
Now a single day compensation for the remaining 26 square feet area shall be rupees 17.94 per day. 20 multiplication has been shown. Thus the decree holder is entitled to receive rupees itna per day compensation for the remaining area of 26 square feet. Thus the judgment after is directed to pay rupees 17.94 per day compensation to the decree holder from the date calculated since 21/1/2000 till the date of the delivery of this order as well as delivery of the cash possession of the remaining 26 square feet to the decree holder. So the decree is, Lordship, that if the predecessor interest of the respondent, Lordship, will fail to give possession of the 345 square feet and fail to fulfill the other terms and conditions, the compensation of rupees 500 per day will be paid, Lordship, to the present petition. So that decree has been modified by the learned executing court, and the learned executing court does not have any power to modify the decree.
That understood, but it is the fact that out of 345, 319 has been handed, 319 square foot of area has been handed over to you.
No, Lordship, but
This is the
other
modification. This is
terms
the-
and conditions were also not
This is only a
fulfilled.
calculation.
At this
If-
stage,
If nothing was handed over to you, then some modification was done. Now the only the amount, 500, that has been made proportional.
no, Lordship, the
We'll issue notice, but we're not-
only I am praying only for notice. No, I have no prayer for stay.
no, there cannot be any prayer for stay also. And I think we can
Other side should be heard.
heard PSP Roy, Senate Council for the petitioner who by means of this application has put to challenge and order dated
27 page
27
103.
2023 passed by the learned Munsif number 1, Kamrup in title execution number 12 of 2007 to 12 of
12 lots,
12 of 2007.
7.
The learned counsel broad submission is that by the impugned orders, comma, the learned executive court has modified the decree which is beyond the powers of jurisdiction. Court of issue notice returnable by 4 weeks. Last step for service of notice upon the respondent be taken by registered post which is the step by tomorrow.
Abla.
May I please, your lordship? Lordship, in this revision petition, lordship, the petitioner is the wife, lordship. And respondent is the husband, lordship, who had filed an application under section 13 of the Hindu Marriage Act 1955
Who
in
had
the
filed?
Learned Family Court below.
Husband has filed.
Yes, lordship.
Husband filed against
Husband filed an application under section 13 of
you.
the
Against you.
Yes, for decree of divorce, lordship.
Yes, thereafter.
And after having received the notice, lordship, issued by the Learned Family Court below, lordship, I appeared on
Which court?
in Family Court 2, lordship,
Here in Kamrup.
Kamrup Metro. Guwahati.
Okay, then
Lordship, having received the notice, lordship, I participated in the proceeding suit, lordship. And lordship, on the very first day, 25/8/2023, lordship, the case was fixed for service report, lordship. Though it was, lordship, fixed for service report, lordship, the petitioner thought that on the very first date, she should file the written statement. Therefore, she filed an application praying for some time, lordship. And on the very first day, lordship, the case was transmitted to the counseling officer, lordship. And on the first day, lordship, both the parties appeared before the counseling officer, lordship. And on the very first day, lordship, first counseling was conducted, lordship. And in this way, lordship, 3 counseling had been completed, lordship, but the counseling failed, lordship. And thereafter, lordship, the case record was remanded, lordship, to the original court, lordship, wherein another date was fixed by the Learned Court below, lordship. Lordship, and lordship, after completion on 21 March of 2023, lordship, third counseling was completed, lordship. And on the very date, lordship, the Learned Court below fixed next date as 26/5/2023 for written statement, lordship. So it was the first date for written statement, that is 26/5/2023, lordship.
the date will be counted from which date? You have already appeared.
Pardon, lordship.
You have already appeared.
Lordship, I have already appeared, lordship, but Learned Court below high order dated 5/7/5/7.
When did you appear first?
25/8/2022. But that was
8/22 appeared.
But that was not fixed for written statement, lordship.
Doesn't matter.
Yes, lordship.
What is the requirement of law?
Lordship,
Then you need to file a written statement
lordship,
for which
so-
a particular time is framed.
lordship, though,
Is there has to be an order that unless the order is there to file written statement, you are not required to file. Now, how much is the delay now?
lordship, according to lordship, 26/5/2023, lordship,
Yes.
there is no delay, lordship. Because your lordship, on the very first day, the case was transmitted to the counseling officer, lordship. After completion of 3 counseling, lordship, time is can be calculated from 26/5/2023, lordship. So even before completion of 90 days, lordship, wide order dated 5/7/2023, lordship, my another petition was rejected by the Learned Court below, lordship. And thereby, lordship, I was deprived from filing the written statements. Now the case is fixed on 2/8/2023 for issuance documents, lordship. Even before completion of 90 days, lordship.
Is your written statement ready?
Yes, ready, lordship. I am ready to file on the 2/8/2023, lordship. Lordship, if I am deprived from the benefit of written statements, Lordship, I will get prejudiced.
You are not deprived of, you did not file it during the opportunity granted. Were you prevented by somebody from filing the written statement? Your wrong understanding of law will that be an excuse? You had entered appearance on 25/8/2022 and chose not to file the written statement.
Lordship, but the very first day, Lordship, the case was fixed for only for service report, Lordship. The petitioner thought that to file the written statement on the very first day.
Thinking will not do. You file your written statement. If counseling is successful, the matter ends there. If it is not successful, the matter is good for a contest.
Lordship, even in that Lordship, in that view, Lordship, Order 8, Rule 1, Lordship, it is not mandatory provision, Lordship, but directory,
So
Lordship.
these are all scale kind of submissions, mandatory, directory.
Lordship,
This happened decades back. Don't make those kind of submissions.
Lordship,
Mandatory, mandatory.
because of some genuine ground, Lordship, I filed adjournment law. I filed petition for adjournment, Lordship. And Lordship,
Okay,
so
what is
far,
your name? What is your name?
Lordship, so far the
Your name?
AK Ahmed, Lordship.
Third A.K. Ahmed Learned Counsel.
Yeah.
For the petitioner who has filed this petition under Article 227 of the Constitution of India against an order dated Section 115 of the CP against an order dated 5/7/2023 was by the Learned Family Court 2 Kamrup, within bracket M, in FC Civil File 902 of 2022 put up by the impugned order, comma, the petition number 509 of 2023 filed by the petitioner praying for time to file written statement has been rejected on the ground that 90 days is over. Put up. The Learned Counsel has submitted that due to some mistaken notion, comma, the petitioner, who is the opposite party in the proceeding filed under Section 30 of the Hindu Marriage Act, comma, the written statement was not filed, which otherwise is ready and can be filed immediately. It is also submitted that if that in the absence of a written statement, comma, grave prejudice would be suffered by the petitioner. Full stop. Issue notice returnable on, when is the next date?
2/8/2023.
Returnable on on 9th of 9/8/2023. That steps be taken for service of notice upon the respondent by registered post with 80. Steps may be taken on all the three addresses given in the petition. Full stop. Additionally, comma, the petitioner is at liberty to call justice service upon the respondent, and such justice is to be routed through the registry of this court and in the notice accompanying the justice, comma, the next date is to be reflected. Full stop. Learned Counsel is also at liberty to don't say learned counsel. Parties are also at liberty to inform the respondent on the next date fixed before the learned family court. Court of Para. The learned counsel prays for an interim order.
Lordship.
Court of Para. Considering the above facts and circumstances, comma, this court is of the opinion that interest of justice would be served if the further proceeding in so and so, in what is the name of the case? Further proceeding, what is the number of the case? Further proceeding in FT Civil Code 90 is kept in abeyance. However, considering the nature of the issue involved, comma, while directing that further proceedings in the aforesaid case before the learned family court number 2 Kamrup Metro would remain suspended, comma, an endeavor would be made to dispose of this petition on the next date on the appearance of the party.
Obligation, Lordship.
Take step given by justice and inform the parties on the next date.
My lord, in this case, my lord, I am aggrieved by the order dated 9/5/2023, my lord. Whereby the prayer for documents of the exhibits was rejected, my lord. I am only praying, my lord, one limited prayer is that I am the defendant number 3 in this case, my lord. Suit was filed in 2019 and the evidence was filed.
You are the defendant.
Defendant number 3.
2.
3, my lord.
3, okay. What is your grievance?
The suit was filed in 2019. Then the evidence on affidavit of the plaintiff witness was filed on 19/1. 19/1/2023 with 20 exhibits. Copies.
PW1.
PW1.
Chief.
Chief. With 20 exhibits, copies of 20 exhibits, which were not furnished to me. Then again on 2/3/23, and the PW2 had filed his evidence along with 5 exhibits. Copies were not furnished to me. So on 9/5, my lord, 9/5/23, in between there were 2 dates, my lord, 9/5/23, when I had filed a petition for that I may be given the copy of the exhibits, but the learned court below, my lord, at page 135, had passed the impugn order, whereby the prayer for adjournment was rejected, my lord. May I read the report, my lord, the order, my lord?
135.
135. Seen report furnished by the learned advocate commissioner stating that 2 PWs are present, but learned counsel for the defendant has filed petition seeking adjournment, which happens to be third adjournment taken for cross-examining the PWS. Learned counsel or the defendant move petition number so and so before this court seeking adjournment by citing that plaintiff has not furnished the exhibits along with the evidence for which cross-examination could not be done. There is no provision for furnishing exhibits, and learned counsel was given the liberty and access to inspect those exhibits of the plaintiff, but he refused to cross-examine the witnesses as the ground showing seeking adjournment is beyond resonance. Prayers sought seeking time for cross-examination of PW 1 and 2 is rejected, and cross-examination by the defendants is dispensed with. The evidence of PW 1 and 2 will be appreciated for purpose of this suit. Taking so and so. So on the ground that there is no provision under the CPC, it was rejected, my lord. But under order 18, my lord, if my lord may kindly peruse order 18.
Yes.
Order 18, rule 4, my lord. In every case,
yes,
the examination in chief of a witness shall be on affidavit, and copies thereof shall be supplied to the opposite party by the party who calls him for evidence to the other party.
Copies thereof means
Thereof
what?
of the evidence. Then
Of the affidavit.
of the affidavit. Then provided that where documents are filed and parties rely upon the documents, the proof and admissibility of such documents which are filed along with such affidavits shall be subject to the orders of the court.
See, the obligation is only to give the
The
evidence.
evidence. But the issue in this case was that the documents which they are relying upon, the exhibits, are very voluminous in nature, my lord. So it was around more than 100 pages, my lord. So when that day itself, the court said that you do the cross-examination.
When was the chief filed?
Chief was filed on
19-1.
19-1.
Then
Then
you
the
took-
second
you took
evidence,
You took 3 adjournments,
the second evidence was filed on
2-3.
2-3.
Your petition was rejected on 9-5.
9-5, my lord. So only humble prayer, my lord, that because
Don't
it
find-
is
find
it
any,
is a fair, because the right of cross-examination is a right.
Are you deprived from that right?
No, because I will not be able to cross-examine the plaintiff witnesses, my lord.
Why?
Because the opportunity has been closed, my lord.
What did you do during the opportunity which was made available?
Because I was not aware, my lord, because
We don't find fault with this order. There is no glaring error in this order.
my lord,
From 19th of January, the order has been passed in May. You have not taken a step to either get certified copy of the
and
documents or inspect the documents.
we were the impression that because it's a voluminous in nature, my lord, those documents, we were the impression that they will serve as a copy.
If they voluntarily give you the documents, good.
Otherwise, my lord, we will obtain it from certified copy from the
You
court.
should have done.
One chance may be granted, my lord.
Yes, what do you say? You are for the plaintiff,
For the opposite party, Your
plaintiff.
Plaintiff. May I draw your honor's attention to paragraph 6, Your Honor, of the revision petition at internal page 8.
Eight.
8. Paragraph 6. That the petitioner humbly states that the respondent number 1 on 9.
What is your name?
My name is D. Goswami, Your Honor.
Yes, you sit down.
That the petitioner humbly states that the respondent number 1 on 19/1/2023 had filed the evidence on affidavit on behalf of the plaintiff witness number 1.
Correct.
On the next date, on 2/3/2023, the evidence on affidavit on behalf of plaintiff witness number 2 was filed before the learned trial court. It is to be stated herein that although the evidence of PW1 had 20 numbers of exhibits and the evidence of PW2 had 5 numbers of exhibits, the same were, however, not furnished to the counsel for the petitioner. The said fact came to the knowledge of the petitioner on 8/5/2023 when the counsel for the petitioner informed the petitioner. After the evidence of PW2 was filed on 2/3/2023, the next date was fixed on 21/3/2023 for report of the commissioner. It is pertinent to mention, state herein that on 21/3/2023 and 6/4/2023, the petitioner was under the bona fide impression that the respondent number 1 would serve the copy of the exhibit. So it is evidently clear, my lord, that the matter was listed before the trial court on 21/3/2023 and 6/4/2023.
No, in fact, the impugned order has also said that there were adjournments sought for.
Yes, my point being, Your Honor, the matter was listed before the trial court on 21/3/2023 and 6/4/2023. The matter was listed before the commissioner on 3 occasions. Altogether 5 occasions, my lord. And while taking those adjournments, they did not allege that a copy of the exhibits has not been furnished to them. After availing 5 adjournments, only thereafter they came up with the allegation that the copy of the exhibits has not been furnished to them. So this is a very rightfully passed order.
Okay, you pay cost. You pass an order. You pay cost, you get the copies, certified copies, will grant a reasonable time, but we are not going to interfere at this order. Third, 3S concept for the, you are on caveat.
And the caveat.
Right, in the caveat. Third, 3 Goswami, Learned Counsel. Learned Counsel who has filed this caveat in connection with an order dated 9/5/2023 passed by the learned civil judge Dharam Mohan in MS number 4 of 2019. The caveat would be heard in the event this court proposes to pass an interim order. Caveat can be heard in the main petition, you write, heard as counsel for the petitioners also heard Sri G. Goswami, learned counsel for the all the respondents,
Only
first respondent,
The remaining are the dependents, my lord. They're
for the respondent number 1, who has then appeared on the strength of a caveat. Full stop. The petitioner is the defendant in connected manuscript number 4 of 2019. And this petition under Article 227 of the Constitution of India has been filed against an order dated 9/5/2023, passed in the same manuscript by the learned civil judge Sarah Moholder. Para. We found the learned counsel by drawing the attention of this court to the impugned order dated 9/5/2023 has submitted that the prayer for adjournment of the petitioner has been rejected, and whereby the petitioner has been deprived of an opportunity to contest the case properly, as he would not be able to cross-examine the plaintiff witness number 1 and petition witness number 2. He submits that though the examination in chief was filed by way of an affidavit, and copies of the said affidavit were furnished, the documents accompanying the affidavit were not furnished. It is submitted that the PW1 in his chief examination has exhibited 20 numbers of documents, whereas the PW2 had exhibited 5 numbers of documents, and those being voluminous in nature, the petitioner was under the impression that copies of the same would be furnished, and therefore he would be in a better position to conduct the cross-examination. He accordingly submits that the order dated 9/5/2020 is to be interfered with. Per contra, Sri Goswami, the learned counsel for the respondent, has submitted that there is no error at all in the impugned order dated 9/5/2023. He submits that after filing of the examination in chief, the matter had come up before the learned court on 2 occasions, namely 21/3/2023 and 6/4/2023, and also on 3 occasions before the learned commissioner, before whom the cross-examination was to be done, and the petitioner had failed to take any step for procuring the documents or to inspect the state in accordance with law. Full stop. He accordingly submits that the instant petition is liable to be rejected. Full stop. Order 18, Rule 4 of the CPC is with regard to recording of evidence. Full stop. As per the same comma, the same reads as follows. The relevant part of the same reads as follows. Para. Code provision. The obligation as per the statute is to serve copies of the affidavit which has been filed as chief examination. And so far as documents are concerned, comma, there is no requirement in law to serve copies. Full stop. The only requirement is that where the documents are filed and relied upon, comma, the proof and admissibility of such document would be subject to the orders of the court. Full stop. It is a different matter altogether that a party may choose to serve copies of the documents which have been exhibited and annexed in the chief examination. However, comma, the same cannot be held to be a mandatory requirement, and therefore this court is of the opinion that the order impugned in this case does not suffer for any infirmity which requires interference by a revisional court. Full stop. This court has also seen, has also noticed, this court also finds force in the submission made on behalf of the respondent that there were plenty of opportunities from the date of filing of the chief examination till the impugned order dated 9/5/2023, when the documents would have been procured, which have not been done. In view of the above, comma, this court is of the opinion that the order dated 9/5/2023 passed by the learned Court of the Civil Judge Darang, Mongol, does not call for any interference. However, comma, however, in the interest of justice, comma, this court is of the opinion that while the impugned order is not interfered with, comma, the petitioner may be allowed one last opportunity to either inspect the documents or procure the same in accordance with law, for which a period of 2 weeks from today is granted. Full stop. This court is also of the opinion that since the suit is pending since the year 2019, the petitioner are liable to pay cost of rupees 2,000. Full stop. Ordered accordingly. Petition accordingly stands. Full stop.
We may be allowed to cross-examine after we get this certified copy.
Obviously, we said the learned court may accordingly fix the date after 2 weeks, giving an opportunity to the defendant to cross-examine both the PW1 and 2 in accordance with.
Yes, last chance, my lord.
We have some last opportunity.
Not of.
So I think she may not be inclined to take up this matter.
Who's there?
Page number 40 is there, Lord.
40.
Yes.
Are you sure this is?
I have otherwise no issue, Lord.
No. Name is there.
Yes.
There is another advocate by this
Yes,
name.
maybe lost,
I will not remember this case.
but I've just not checked it, Lordship, that's why I'm. The issue is with regard to the
Which year? 2013.
13.
Case of where case of which?
Karimganj, Lordship.
Karimganj.
Yes.
That was- So the apprehension if your
I've just
raising
clarified that
if-
thing. Yes,
if the name from the name, we are not very sure.
I've just clarified that thing, Lordship. I have no
don't
other
think
issue.
so.
Then I'm just pressing this matter,
No,
Lordship.
no, I don't think so that
Yes, Lordship.
this court has dealt with this matter.
Then here in this case, Lordship, this, the previous
No, 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 no.
application,
We'll take it at 2 o'clock. You have a talk with your colleague by the name. Because we don't remember anything about the fact. Normally we remember.
May I please, your lordship? My lord, in this case, my lord, in a money execution case, my lord, I have paid the entire amount to the judgment creditor. I am the judgment debtor, my lord. I paid the entire amount. Matter is settled, my lord. Both the parties filed my joint application before the London civil judge on 6/7. I am the my lord,
You have paid the declared amount.
my lord.
Then
Thereafter, my lord, the joint application is filed, my lord.
For
Close this matter of this money execution. We both the parties filed joint application on 6/7, my lord. I am the my lord, the head teacher, my lord. Departmental action is initiated due to this case, my lord. So there is urgency to have this matter.
now we remember you have mentioned this matter.
Yes, ma'am.
Some urgency is there. What is the order passed by the London Trial Court, Land Executing Court?
London Executing Court, my lord, fixed this matter as the matter was fixed earlier on 19/8. So London civil judge said that it will be hard on 19/8. My urgency is there, my lord. On 6/7, we have filed the petition, my lord. So one direction will be given to the London civil judge to have this matter in urgent manner. This is a simple prayer, my lord.
We haven't heard the other side. If they say something else,
My lord, so that my lord, if the London civil judge satisfied that,
we haven't heard the other side. Can you dispose of the matter like this? If their version is something different,
they may raise this issue before the civil judge. If there is that joint application is, I have annexed, my lord. I have annexed, my lord.
you have annexed, no doubt, but we have not heard them. This court has not heard them. Can you serve them dusty?
No, man.
Can you serve them dusty?
I can, man.
When is the next date?
Next date on 19/8.
19. Today is what? 20?
Today is 26/8/7.
When do you want the matter to be disposed of?
My lord, I am seeking today, my lord.
No, today we are not. No. When do you want your matter to be disposed of there?
Even maybe tomorrow, day after tomorrow, we are urgency, my lord. Otherwise, nothing else.
What is the urgency? Tell us.
Urgency, my lord. Departmental action is initiated, my lord.
Where?
This I have annexed, my lord. Just page 90, my lord.
19.
90.
90.
Yes, my lord.
Yes. No, this is the order. Where is the departmental action?
Action, my lord, kindly see that page 92. Holding up of the salary of Sri Imdad Rahman Lashkar, headmaster, Fulbari High School.
You can take this up an independent proceeding. Challenge this. Will it be proper for us to interfere with the learned lower court?
My lord,
this is an independent action. They say that the case is pending. You say that the case is in proper path, will be a formal order needs to be passed. Now, in this, department is not connected to this proceeding.
So, my lord, we have to.
The final petition will say this. See, we don't have the problem in passing an order, but we cannot pass the order without hearing the other side.
This is right, my lord, but party, the learned civil judge will heard the matter on both the parties, my lord. If that may be direction to the civil judge,
On 19 itself.
not
on
my
19th.
lord, within a week, my lord.
How can we pass that without the other side?
Even maybe the in direction, my lord, in the order it
How
may
can you
say,
pass that without the other side? Other side is aware of the date, next date, 19/8. If we fix a date tomorrow or day after, how will they be aware? That is why we're asking if you can serve them dusty. We can have it sometime in the next week, next Friday, and pass an order for expeditious hearing, or you appear on the next date, have it done. Or you file a writ petition against this small writ petition. This is the fact.
we'll file dusty, my lord.
File dusty. Heard. 3 H.R. Chaudhary, Senate Counsel for the petitioner. Who by means of this application under Article 27 of the Constitution of India, prior to Section 151 of the CPC, has prayed for a direction to the Senate Executive Court to dispose of money execution case 2 of 2018. Court of is the para. It is the case of the petitioner who was the defendant in manuscript number 1 of 2015 filed in the court of the Muntif, Karimganj,
Yes, ma'am.
that the same was amicably settled and
My lord, case is pending, learned civil judge, current.
Why?
Civil judge.
Civil judge.
Yes,
What is the amount involved?
amount is 3 lakhs.
3 lakh civil judge.
Yes, yes.
Oh, it's the civil judge, huh? And the petitioner claims to have satisfied the amicable to have paid the entire amount as per the amicable settlement, and the matter has been fixed on 19/8/2023 before the executing court. However, the predicament suffered by the petitioner is that a departmental action is being contemplated only on the basis of pendency of the same case. Three, Chaudhary the learned counsel praised for an expeditious disposal of the matter by a director to expedite the hearing by the learned executing court so that the department may be apprised of the closure of the case. This court is, however, of the opinion that without issuing notice, the notice to the respondents, it may not be proper to dispose of this matter. Accordingly, that notice be issued returnable on yes, when 19th is the date your matter will be instructed. Returnable. When can you serve? How soon can you serve?
Will serve by Monday, my lord.
Today is 26. Returnable on 7th. Returnable on 7th of August 2023. That steps be taken for service of notice by registered post PDD, steps within tomorrow. Put up. Justice service is also permitted, which is required to be routed through the registry of this court. And in the notice accompanying the justice, comma, the next date is to be reflected. Full stop. The petitioner may file an affidavit prior to the next date in proof of such justice. Full stop. Para. It is also made clear. It is also this court is also of the opinion that taking into consideration the peculiar facts and circumstances, comma, an endeavor would be made to dispose of this petition on the next date on a clearance of the party. You have the other option, file a writ petition. That is the best option for you. Her and her B. Hussain, Neelam, A. Tawfiq, and appears for the petitioner on call. Para. In the interest of justice, please after 2 weeks.
May I believe your lordship after some time, please.
The amendment petition was without an affidavit.
Lordship.
You don't have the brief.
Yes, lordship. No, lordship.
Why? You're not required to have the brief. Are you there in the case or not?
Lordship.
Are you there in the matter or not?
No.
You don't know about this matter.
No.
You are not with MSR Chaudhary.
Yes, also there is lordship.
Then why aren't you aware of the
Another
matter?
lordship. So they another go to another purpose.
Why aren't you aware of the facts of the matter?
14 lordship. Lordship.
Why aren't you aware of the facts? Why don't you know the facts of the matter?
I know lordship. No read lordship. Discuss.
What is the case about?
CRPI lordship.
Why have you filed?
Land. Lordship.
You should know the fact. It's not very difficult to know the fact. Your amendment petition was without an affidavit. It was rejected. Your prayer for rectifying it has been rejected. Yes, sir, after some time follow.
After deeply.
May it please your lordships. My lord, this petitioner is the plaintiff lordships. Suit is for specific performance lordships. Lordship, this my husband lordships. He entered into an agreement with the defendant lordships. And lordship, my husband expired due to motorbike accident, leaving me and two minor daughters lordships.
You are the plaintiff.
Plaintiff.
So for the specific permanent.
Lordships.
By your husband.
Lordships.
He passed away.
Passed away due to motorbike accident, leaving behind me and two minor daughters. Lordship, total price consideration is 3,50,000. Out of 3,50,000, 3,35,000 was paid lordships at that time. By
You had paid.
My husband paid.
Oh.
Lordships. And lordships, I filed the suit lordships. And when the suit was filed lordships, at that time, I had the financial problem. With permission, I have filed a suit that I will deposit the court fee later on lordships. But in due time lordships, I could not submit the court fee lordships. And accordingly lordship, the suit was dismissed for default lordships. Then I have filed an application lordships for restoration of the suit and that was rejected, lordships. Lordships, against that, lordships, I have approached before this honorable court, seeking a direction by this honorable court that whatever court fees, dear lordships, I'll deposit before the honorable court, lordships, and let the suit be proceeded by the honorable trial court, lordships. This is my humble prayer, lordships.
Rejection of a suit, isn't it appealable?
Lordships, it is not available. I have filed the application under Article 227, lordships.
No appeal lies.
No appeal lies, lordships. I have this one gone through the order 43 and 41 also. Appeal does not lie, lordships. And accordingly, lordships.
Where's the 1D, I think. 1D.
Either.
Oh, 43, lordships.
Yes.
Order 43, C, lordships.
Yes.
An order under Rule 9 of Order 9 rejecting an application in a case open to an appeal or an order to set aside the dismissal of a suit. Lordships, order C, Rule C, lordships, it is having connection with Rule 8, lordships. Rule 8, lordship. Rule 8, in case of only defendant appears, lordship. In my case is entirely different. I could not deposit the court fee in time, lordships. And because of that.
No, that is not the issue. The issue is the dismiss for default.
Dismiss for default.
The order which is presently before us is a dismissal for default order. The order by which the suit was dismissed for non-deposit of court fee, that is a different matter. Thereafter, the suit, the application was dismissed for non-prosecution. If it's a non-prosecution, then why C will not come into operation?
Because, lordship, this C.
Let us see the impugned order.
Lordships.
Let us see the impugned order.
Lordship, page 30, lordships. Page 30. Order dated 5/9/2013, lordships.
30.
30, lordship.
Yes.
Learned advocate for the plaintiff has filed Hajira. The instant order pertains to petition number so filed with the plaintiff. The petition has alleged in the petition that she was required to pay the ad valorem court fee in the suit, but she could not do so because of her financial problem. Her husband had expired due to road accident on 6/12/2010, leaving behind 2 minor daughters. Her parents also expired due to old age ailments. Therefore, she could not pay attention to the suit, which was dismissed for non-prosecution. It is prayed that the suit may be restored to file and the plaintiff may be allowed to deposit ad valorem court fee. It appears from the order sheets that the suit was filed way back on 3/1/2012 with deficit court fee. It appears from the order dated 10/7/2012 that due to non-persuasion by the plaintiff, the case was lying without any order for over 6 months or so. Next date was fixed for depositing the deficit court fee on 30/7/2012. The plaintiff remained absent thereafter for 3 days in a row, and eventually on 21/9/2012, the suit was dismissed for non-prosecution. Hence, the conduct of the plaintiff in this suit, which reveals from the order sheets, does not convince me to pass any order in her favor as prayed for in the petition. The petition accordingly stands rejected. In view of rejection of the above petition, the suit shall remain dismissed for non-prosecution as per order dated 21/9/2012. Non-prosecution as per order dated. Lordships, If at all lordships, I will pay a cost lordship, little
No,
bit.
no, no, we are on the procedure. Your prayer, we have to consider if you have filed an appeal. Now, this is a revision. This is per se against an order of rejection on for non-prosecution. But this is not for court fee, nothing to do with court fee. Court fee was the initial issue. That petition was dismissed, the suit was dismissed for default. No step. You file application, again no step, nothing.
For restoration. lordship.
Restoration, you did not even appear. What is C? Let us see again.
See, an order under Rule 9 of Order 9 rejecting an application in a case open to appeal or an order to set aside the dismissal of suit.
Yes. Why this is not applicable?
Here it is, lordship, Order 9, Rule 9. Decree against the plaintiff
Yes.
by default bars fresh suit.
Yes.
Where a suit is wholly or partly dismissed under Rule 8, the plaintiff shall be precluded from bringing a fresh suit in respect of the same cause of action, but he may apply for an order to set aside the
This is clearly
dismissal.
applicable. You are the plaintiff. Suit was dismissed. You file an application under Order 9, Rule 9. That is non-prosecution, dismissed. Ultimately, this impugned order has rejected your application. And this is an order under Rule 9, Order 9, rejecting an application. Under what grounds it has not been set? Or your application has been rejected. And the application was filed to set aside the dismissal of suit. Exactly the clearly covers. Mr. Chaudhary?
The order of dismissal that was on 21/9/2012.
Yes.
It is at page number 24.
Yes.
It clearly shows the plaintiff is absent without steps. Peruse the record since last 2 days, plaintiff is absent without any steps, as the suit is dismissed for non-prosecution. Now, the application was filed in the year 2013, that is of May 2013.
Which application?
This application for restoration. It is at page number 25. This application was filed under section 151. The specific provision has not been mentioned for
May
restoration.
2013.
2013. The
Application for restoration.
restoration. The provision is, as per the Limitation Act 122, is of 30 days. But it has been belatedly filed this application. So there is no merit in this application, Lordship, because the
Your
trial
conduct is
court,
very poor.
yes, Lordship, rightly rejected the
You did
application.
not submit a court fee. We can understand you were there were funds problems. But thereafter you are not appearing continuously. That apart, those considerations will come only when you come to us in a proper form, in a proper manner. You
And
cannot
delay
take
condemnation
reports of
petition was also
115.
not there.
Arthur, Learned Counsel for the petitioner who has filed this application under Article 227 of the Constitution of India against an order dated 5/9/2013 passed by the learned civil judge number 3, Kamrup, Guwahati, in title suit number 7 and in petition number 2562/2013 in connection with filed in connection with title suit number 7 of 2012. Full stop. The suit was instituted by the petitioner for specific performance of a contract. Full stop. It is the case of the petitioner that her husband had paid a major part of an agreed amount for purchase of a plot of land, correct?
Lordship.
And accordingly, the suit was instituted for specific performance. Full stop. It has been projected that since funds was since the petitioner was having financial difficulties, the court fee could not be paid at the time of institution of the suit, which was to be paid subsequently. However, when the matter was taken up, there was non-appearance, and accordingly, the suit was dismissed for default on 21/9/2012. Full stop. Thereafter, the petition 2562/2013 was filed for restoration of the suit. Full stop. However, the state petition has also been dismissed, has also been rejected by the appeal order dated 5/9/2013, as the petitioner had defaulted in appeal. Full stop. Sri Sharma, the learned counsel, submits that the order of rejection may be interfered with and an opportunity be granted to the petitioner to contest, to continue with the suit, as he is in a position to deposit the necessary court fee. Full stop. For contract, SP Chaudhary, current counsel for the
Response number 1.
response number 1, has submitted that even without going into the merits of the case, the instant petition is not maintainable, as the order impugned dated 5/9/2023 is an appealable order. Full stop. He submits that the suit was instituted on 3/1/2012, and for about 6 months, no steps were taken for deposit of the court fee, as would reflect from the order dated 10/7/2012. He further submits that on 21/9/2012, the suit was dismissed for non-prosecution, whereafter the aforesaid petition 2562/2013 was filed, which was also not pursued, leading to passing of the impugned order dated 5/9/2013. Full stop. By drawing the attention of this court to the to order 9, rule 9 of the CPC, the learned counsel submits that the state provision grants an opportunity to a plaintiff to apply for an order to set aside an order of dismissal for default as a fresh suit is barred. Full stop. Reference has also been made to order 43, rule 1 within brackets C, as per which any order passed under Rule 9, Order 9, Rule 9, rejecting an application of an order to set aside the dismissal of a suit is an appealable order. Full stop. Para. He accordingly. The three Chaudhary, the learned counsel further submit that the conduct of the petitioner has been found to be consistently irregular and there is lack of due diligence to pursue the suit. After hearing the parties from this court is of the opinion that without even going into the merits of the case, the provision contained in the CPC clearly provides for filing an appeal against an order passed in a petition filed under Order 9, Rule 9 of the CPC, which has been put up. There is no manner of doubt that the impugned order dated 5/9/2013 has been passed in a petition to set aside an order of dismissal for default, and such application has been preferred by the petitioner who was the plaintiff. In view of the aforesaid provision of law, this court is of the opinion that the present petition is not maintainable, and accordingly the same is dismissed. Thank you. You come.
May it please your lordship. The petitioners are the plaintiff's lordship. They are the sisters seeking share from their brother's lordship. And during the pendency of the suit lordship, they filed an amendment application. That petition was without any affidavit, and then they prayed write another petition to swear affidavit, and that to be added with the earlier petition. Both the petitions were lordship rejected by two miscased lordship. That is a mistake on the part of the advocate lordship, that I agree.
Let us see the impugned order.
Lordship. The amendment application was rejected by Annexure 5, page 38, lordship. That is miss case number 61.
And let us see your application.
Lordship.
For the order passed in your application to file affidavit.
Order 6, Rule 17, application Annexure 3, page 32.
Even that petition was not filed, was not accompanied by an affidavit.
Affidavit. The second application file
If
that was
if you continue to commit the same mistake,
lordship.
this revision has an affidavit or not?
Yes, lordship.
Fortunately.
Lordship.
See, your amendment application did not have an affidavit.
Lordship.
You filed an application, even that did not have an
That
affidavit.
next application was filed by the engaged advocate. He verified himself, lordship. He has no guts to call the client for the mistake committed by him, lordship. So, lordship, the second
It's
application
not a
was
question,
verified
it's
by
not a
him.
question of God's sake. It's a question of procedure.
Lordship.
Some mistake might happen. How do you find fault with the order passed?
In fact, lordship, there is.
And where you are trying to invoke our revision jurisdiction.
Lordship. But lordship, I have found one judgment of Supreme Court says for these mistakes, the petition should not be dismissed, lordship.
What mistake?
Verification and lordship, the affidavit was not shown with the petition lordship.
Let us see under what context.
That was the election petition lordship.
Suit was instituted when?
Lordship,
When did you institute the suit?
inherited land by
When?
lordship,
When? Which year?
suit lordship, suit of 2020 lordship,
New.
lordship.
Well,
And
which
suit is
way?
at the stage of SBPH lordship.
Uh,
Para 21 lordship.
Paragraph 21.
It is further held by this court, whether your lordship,
Paragraph 21.
yes, lordship.
21 is starts with according to the explanation.
Lordship, this paragraph, paragraph 21 lordship, I have marked. Your lordship may take this. This one.
21 starts with according to the explanation.
Lordship. Your
Isn't
lordship
it?
may kindly take up this copy. Lordship. Other copy. Maybe it's the names are different. Maybe
Either Justina.
yes, lordship.
Same case.
Lordship. Very copy and we have this আগত আগে আনালো এটা সাথে মিলানো প্যারা 21 version. Others is rule 15. Order 6, rule 15 says verification of pleadings, lordship. That order 21 reflects in regard to
This
order
is not same case or what?
2011 2 SCC 654, lordship.
On the air copy which you are
Lordship, that
handed
may
over
not
there, we are
really,
not even finding the. I think. You have the extra copy.
no, lordship.
That
The
is why we are
SCC
trying to find it for you.
lordship, para 21,
Yes,
lordship.
it's better help with it.
That was in regard to election petition, lordship. That, but order 6, rule 15 was discussed.
No, this is on a different context.
But order
The
6,
rule 6 and 7 of the rules of 1994 were held to be directed, and therefore non-filing of the affidavit under order 6 rule 15 was not held to be
lordship, it was in regard
under
to
those circumstances.
the lordship.
This
Lordship.
cannot have been a direct.
Order 6, rule 15 says lordship verification of pleadings, lordship, and that it is to be verified. The petitioners in this cases verification was done, lordship. Only sub rule 4 that was inserted after 2002, lordship, the person verifying the pleading shall also furnish an affidavit in support of his pleading. That was not done, lordship. And amendment,
Seeking an amendment is not something procedural in nature.
Lordship,
It creates a substantive change,
Lordship.
and you need to give an adequate opportunity to the other side. It's not a matter of right or course.
Lordship.
It can be matter of serious dispute. And we have seen cases where matter has reached the Supreme Court even on a point whether amendment is allowed or not.
Right.
On those aspects.
Amendment, Lordship, the learned trial court has not discussed in regard to amendment,
Understood.
Lordship. On merit, they
So
have not
that is it.
discussed.
The consequence of an amendment can be have a lot of ramifications.
Lordship.
So you need to follow the procedure if you are not filing the affidavit, and even in the application, which by which you had tried to introduce an affidavit, even that has not been verified.
My only submission, Lordship, one
What
chance
is the
may be
amendment
given.
you are trying to bring in?
Lordship,
What is the nature of the amendment?
amendment, Lordship, the
What was the
sisters,
suit filed?
suit was for share, Lordship. Share of the sisters from the brothers, Lordship. By way of amendment, they want to show that the portion of land which they want to abandon, Lordship, that is the Betty land, Lordship. In amendment application, they have stated that the plaintiffs have claimed partition of land of their father, late Dharibuddin Sheikh, which have been described in the schedule of the plain, but apart from the described land in the schedule, there is another land measuring 2 bigha, 1 katha, 1 lessa, owned by the father of the parties, covered by so and so, so and so. This land is homestead land of the defendants. The plaintiffs have not claimed partition over the above said land, as they have abandoned their claim over the homestead land as per law of partition, though all the landed properties should be in the schedule, but as the plaintiffs have not claimed over the aforesaid land, as such a subpara in this regard is highly required to be added after para number 5 of the plain. So that para was within inverted comma thereafter, Lordship, page 33.
Please read it.
Page 33, Lordship.
Please read.
That though the father of the parties had left another plot of land measuring 2 bigha, 1 katha, 1 lessa, covered by patta number 11, dag number 64, stands at village Bhitor Chengmari under revenue circle Dangtal, Vidyapur. But the plaintiffs have abandoned the claim of share of this plot of land and hence not included in the schedule of the land. Para 4,
Did you take the recourse of order to rule 2?
suit is at the stage of SPPS, Lordship.
Understood. I have got the CPC.
Yes, Lordship.
Come to order 2. Rule 2. And the sub rule 3.
Omission to sue for one of several reliefs, Lordship.
Yes.
A person,
First you read 2.
Lordship,
to include-
relinquishment of part of
No,
claim.
no, not sub rule 2.
And
Two.
rule 2, Lordship, suit to include the whole claim. Every suit shall include the whole claim of the claim which the plaintiff is entitled to make in respect of the cause of action. But a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court.
Then read 3 now.
Relinquishment of part of claim.
3.
Omission to sue for one of several reliefs. A person entitled to more than one reliefs in respect of the same cause of action may sue for all or any of such reliefs, but if he omits, except with the leave of the court, to sue for all such reliefs, he shall not afterwards sue for any relief so omitted.
This bar will come against you. This is the point you should have taken. Did you take this point? If you don't bring it to the notice of the court now,
Lordship,
later it will be barred by law to bring a fresh suit. But your conduct is in serious doubt. MS Chaudhary. Turn it. Counsel for the petitioners who have filed this petition under Article 227 of the Constitution of India, read with section 151 of the Civil Code. The petitioners who are the plaintiff in title suit 34 of 2020, pending before the Learned Court of Munsif, Bongaigaon, is aggrieved by an order dated 7/6/2023, passed in Miss J. bracket, case number 61 of 2022, whereby the petition number 2665 of 2022, filed by the petitioners under order 6 rule 17, has been rejected. Full stop. The petitioner is also aggrieved by rejection of another petition by which the petition filed under order 6 rule 17, by which an affidavit, by which the defect in the earlier petition was sought to be rectified. Full stop. Learned counsel for the petitioners has submitted that due to inadvertent, the application praying for amendment was not supported by an affidavit, and the same amendment being absolutely necessary for a fair adjudication, the procedural defect ought to have been allowed to be rectified. Full stop. Para. Issue notice returnable by 4 weeks. That steps be taken for service of notice upon the respondent by registered post PTD. Steps by tomorrow. When is the next date?
Lordship, these are the missed cases. Next date is not mentioned, Lordship.
When is the next date according to your
Lordship. For that, I have to take instruction, Lordship. And in fact, Lordship, they have not objected to the second petition, only in the amendment petition, they have filed objection, Lordship.
You don't want to stay up suit
Lordship may dispose it up also, your Lordship.
without hearing.
Lordship.
Without hearing.
Lordship.
Without hearing, we're not to do.
To consider the amendment
We need to
petition by
take their
the.
views.
Lordship.
Yeah, you file, you served a stay upon them.
Lordship, by upon the engaged counsel who are representing the other respondents before the learned trial court. To him, I can serve, Lordship.
Now, why don't you serve the stay?
Brothers may not take from the. Lordship.
You don't know the next date. So how do you serve the counsel?
Lordship, after some time, I will provide the date, Lordship. I'll take instruction when the next date is.
Ms. Chaudhary, Learned counsel submits that the next date fixed in the suit is ... And if the suit proceeds, it is submitted that prejudice could be called. See accordingly, praise for an interim order. Sarah? Considering that the suit is pending since the year 2020, this court is of the opinion that staying the suit for an indefinite period may not be in the interest of justice. Therefore, let further proceedings in PS 34 of 2020 pending in the court of the Learned Munsif Bongaigaon be kept in abeyance till the next returnable date, which is fixed on 21st of not 21st, 23rd of August. 23rd of August. Full stop. The parties are also at liberty to inform the Learned Counsel appearing for the respondents in the trial court regarding present proceeding and the next case.
Lordship, I'm there.
Endeavor would also be made to dispose of this petition on the returnable date on appearance of the party.
Obliged.
You take this date
Lord.
and you give the date. Yes, Dalan, what is this?
Well, previous lordship. This revision has been filed. The petition referring lordship for the plaintiffs. The rent control under the rent control ejectment suit was filed, and London trial court has.
You are the landlord.
Yes, my lord. London trial court has decreed the suit both on the ground of defaulter and as well as bona fide. But in appeal, the finding as to default was reversed, although the decree of ejectment was upheld. On that ground, we have filed this revision, and the connected division has been filed by London, the dependent tenant.
Okay.
Selling both the trial court's judgment as well as.
Here it is.
Yeah, LCR has also received, my lord.
Here it is.
Lordship, let the matter be admitted because he has also grievances. After all, the impugn order is same. Impugn order
It is
24
all-
1
it's all wrong,
2019.
my lord.
Well, here it is. We'll have a date, whether it's at a stage of admission or hearing. This the tendency of which year?
Tenancy of 11, my lord. Suit is of 11.
Two of 11.
Yes, ma'am.
We had
So, my lord.
heard British Alternate Council for the petitioner in CRP 61 of 2019, whereas the PK Bhagavati Senate Council is appearing for the petitioner in CRP 17 of 2021, and both these petitions arise out of a common proceeding which was instituted for ejectment by the ejectment full stop para. The LCR has been received full stop. It's for admission hearing today.
Lordship, the item
Are you
13 is,
ready for a hearing?
item 13 is admitted, my lord. 14 is yet to be admitted.
Are you ready for hearing today?
If your lordship pleases, my lord.
Totally another date be fixed. So it is after all, he is also agreed, I am also agreed. It is common law.
So that is why you should take up the matter in right earnest. We remove the grievance of both of you. Make you free.
Lordship, let it come in the next week.
You pass your grievance, you pass your pains to the court, and you go free from the court.
Lordship.
On Tuesday next.
Bless.
Last to key lecture. That is a full stop para. LCR has been received colonic. Let the matter be taken up for consideration under the column, under the admission column on Tuesday next. On which date an endeavor will be made for final disposal of the matter.
Objection.
Mr. Jalan, come up with the judgment.
Yes.
16. Over you are for home. 16.
Lordship.
16 state is involved.
Lord.
The state involved in 16.
Yes, Lordship. I'm the government representative.
What is the matter?
Here in this case, my lord, the petitioner is the plaintiff, my lord, in the court below, and the petition filed for withdrawal of the suit with liberty to file a fresh one. That was rejected. And again, the rejection, my lord, will be for lordship.
Hmm.
My lord,
Withdrawal is allowed.
withdrawal was rejected.
No, it is permitted
My lord,
under the law.
yes, my lord. Yes, my lord.
Let us see the appeal order.
Order 23, Rule 13 of the CPC.
Rule?
My lord, rule 1(3), my lord. Sub rule. Rule 1 within bracket 3, my lord.
Was there any
Where
formal-
the court is satisfied that the suit must fail by reason of some formal defect, or that there are sufficient grounds for allowing the plaintiff to institute a face suit for the subject matter of the suit or a part of the claim. It may, on such terms as it may think fit, grant the plaintiff permission to withdraw from this such suit or such part of the claim with liberty to institute a face suit in respect of the subject matter of such suit or such part of the claim. This is the provision, my lord. There is a clear indication when there is any formal defect, petitioner, a plaintiff may be allowed to withdraw.
Yes, what do you say? About it?
Lordship. They file for the withdrawal after the vital part of the evidence has already been completed. That's why.
Is it a formal defect? What are your grounds? of
Formal
defect?
defect, my lord, there was a partition in
The
between.
suit was for what?
My lord, suit was for right title and for the right, my lord, declaration of khas possession and for other consequential relief.
Suit for declaration.
Yes, my lord, that declaration, my lord, page 12, annexure 1 is the
Declaration of first position. Then?
yes. Declaration of khas possession and other consequential relief.
Okay.
You will find the at page 12 with our plain.
Now, thereafter, what happened? What was the stage? When was the suit instituted?
My lord, suit instituted, my lord, 15 to 2018.
15 to 2018. Good. Okay. Then what happened?
My lord, there was
Who were the defendants?
advocate, defect is, my lord,
Who were the defendants?
defendant, my lord. Here, one Mohali Sheikh.
You had sought the relief against whom?
Basically, my lord, defendant number 1 and 2 is the main, my lord.
Why have you made parties? The ASO and the
My lord,
collector?
my lord, yes, my lord, there is some land is connected with the some Commendal is also related, my lord.
Then what happened thereafter? What was the formal?
My lord, the formal defect is, my lord, there the paragraph 3 of the plain. There has been statement,
Page.
my lord, ambiguous statement, paragraph 13, my lord, page 13, paragraph 3.
Yes.
There was a partition in between the plaintiff and the defendants 1, 2, and he also got one bigger land after death of mother, but which part of the land my lord, there is no clear statement as regard the land left by mother, and there was exchange in between the plaintiff and the defendant number 1, and from which part he has exchanged, there is no clear description.
Is that a formal defect?
Yes, my lord, formal.
It's not a formal defect. What is a formal defect?
My lord, when the statement regarding the suit property is not properly specified and described.
This is substantial defect. They have already contested the suit. Now, if you are allowed to.
Description is not proper, my lord. That is the ambiguity is there, my lord.
If
My lord,
if ambiguity is an ambiguity of formal defect.
yes, my
Aren't
lord.
they entitled to take
Yes.
the advantage of such statements made in the plain? And should have proceeded. They have filed the WS. At this stage, we cannot allow you to lock in the loopholes.
My lord, some ambiguity is there, my lord.
This
Clear
is an
ambiguity.
attending process. Next time again you say some formal defect left out after the contest. We also have to take notice of what stage you have come to the court. It's not at the initial stage. There's something formal defect notice. Now they have filed WSN. Mr. Gogoi says it's the stage of evidence.
Yes, Lord.
Government evidence decision. Government has not. My lord, evidence, the case was,
Already.
WS was filed by the one, defendant number one, not by the state.
That doesn't matter.
Doesn't make a difference. So plaintiff lordship, we have, as per direction of the concerned circle officer, we have filed the affidavit. We have filed affidavit, and this affidavit, in that affidavit, para 4 lordship, page.
Affidavit in this proceeding.
Yes, lordship. Page 34 lordship, para 4.
Just a minute.
Lordship.
Lordship may,
We will come to you. Let him finish.
Lord.
Lordship may fix another date, my lord. I will, my lord, and let me be clear about the formal defects, my lord.
See the defect which you are trying to show in paragraph 3.
Yes, my lord.
This, in our opinion, may not be
My
formal
lord.
defect.
Yes, my lord.
And
My lord, there was ambiguity about the statement of the land which he got and
there
which
are
was
many-
exchanged.
There are many decisions which has explained what is a formal defect.
Right.
What is a substantial defect? We may not allow you to file a new suit or even amend the suit to make change of a substantial defect, and which has also been already been noticed and defense has been put forward.
My lord, any other day may be fixed, my lord. In a short date, my lord, I will.
Okay. Mr. Gogoi, any tell us the date of your conflict. After hearing for some length, comma, 3A or 6 the learned counsel for the petitioner prays for some time to take instructions put up. Also, 3T or Gogoi, learned state counsel, put the parent as agreed to by the parties list on Wednesday next.
My lord.
Lord.
Date to diva.
Possibly.
Wednesday. 2. Second.
Development.
And please come up with decisions. What is the formal defect? Item.
Seventeen, 18, lordship, the petitioners are same, respondents are different. Lordship. Regarding lordship, in this case, the petitioners are the defendants, lordship. Suit was for right title, interest and recovery of possession. That was decreed, lordship.
Thereafter.
Lordship, thereafter, we filed an objection petition that was not considered by the executive.
Objection where?
Objection, lordship, our case is that.
And at what stage?
Execution stage, lordship.
In the execution.
Lordship, without filing any first appeal, lordship. As because, lordship, during the last, after passing of the judgment, lordship, there is a change of pecuniary jurisdiction, your lordship, due to the amendment in the act itself, lordship. So the client sent the entire brief to the High Court for preparing regular first appeal, but it was not filed at that relevant point of time. When I have accepted this brief, lordship, I advised them that the regular first appeal will be maintainable before district judge. So accordingly, they have filed one regular first appeal, stay application and condonation application. So
filed.
Yes, lordship. The condonation maybe that was allowed, or today is the hearing for condonation, stay or appeal, lordship, before the learned first appellate court.
Initially, was it filed in this court? No.
No, lordship. The brief was returned to the
Returned.
client's lordship.
It is not a case that it was remanded by this court.
No, no,
because of
lordship.
jurisdiction.
No, lordship. It was not filed as because by that
How
time,
much
the
was the delay in filing preferring the appeal in the first appellate court? Around?
lordship judgment was passed.
No, this particular revision is for what?
Lordship, judgment was passed 28th day of February 2020. And I have preferred this revision 24/11/2022. Thereafter, the first appeal was filed.
No, this revision is for what?
Revision, lordship, my section 47 petition was not considered against that, lordship.
What is the objection for? In the
Objection, lordship, the judgment says the partition to be done by the government authorities. And thereafter, lordship, if the plaintiffs were found they are dispossessed, they may be put into possession. So the learned executing court, lordship, directed settlement officer for survey. That was the objection raised by the defendants, that lordship, settlement officer is not the competent authority for survey and demarcation for partition. For partition, the deputy collector is the main competent authority, and lordship, with it is the civil court only who can say whether the plaintiffs were dispossessed or not. It is not the government who can say that the plaintiffs were dispossessed or not. On those ground, objection was filed, that objection was rejected, lordship.
Let us see. Let's see the order.
Yeah.
Page 55, lordship, annexure 7.
Come to the operative part.
I have considered page 61, lordship.
Did you pray for appointment of a receiver?
Appointment of a receiver filed by the judgment decree holder, lordship, that was rejected. I am not challenging that part, lordship. Only so I am challenging the impugn order
Court
part,
came to a finding that the plaintiff is already in possession of majority part of the land.
lordship.
And for meager part, the prayer for appointment of receiver has been had to be unjustified.
Lordship.
And then what is your grievance?
My
Where is your consideration?
page,
The order?
page 61, lordship. I have considered last paragraph,
Yes, that we have read.
lordship.
That is the part by rejecting there, but where is your
Oh,
rejection?
lordship. My objection, lordship, page 57. Perusal of the judgment shows that a competent authority is to demarcate the suit land, and I do not find any fault in such observation. But the said direction cannot be said to have taken away the power of the executing court to execute the decree by directing the competent authority to get the land demarcated and to put the decree holder in possession over the Schedule 1A land, which is specifically being held to be proved by the court in the judgment in question. The submission of the learned advocate for the judgment debtors that the competent authority to demarcate the land is the district collector, and it is for the decree holder to approach the district collector for demarcation is not acceptable in my considered opinion, as because when court passes the decree, it is the duty of the court to get the decree executed, and the duty cannot be casted upon anyone else, including the decree holder or the district collector. Hence, I am of the considered opinion that in view of the decree put for execution, this court has ample power to execute the same by getting it demarcated through competent authority and by putting the decree holder in possession of the land which is found to be dispossessed after demarcation. Hence, the objection raised by the judgment debtor being not sustainable in law as well as in facts of the present case stands rejected. Lordship, as per section 54 of CPC, lordship, the competent authority is the deputy collector, lordship. Section 54, lordship, partition of estate or separation of share. May I read? Where the decree is for the partition of an undivided estate assessed to the payment of revenue to the government or for the separate possession of a share of such an estate, the partition of the estate or the separation of the share shall be made by the collector or any gazetted subordinate of the collector deputed by him, lordship, in this behalf, in accordance with the law, if any, for the time being in force in relating to the partition or the separate possession of shares of such estate. And Order 20, Rule 18 also says,
Yes.
lordship. Order 20, Rule 18, lordship, decree in suit for partition of property or separate possession of a share therein, where the court passes a decree for the partition of property or for the separate possession of a share therein, then if and in so far as the decree relates to an estate access to the payment of revenue to the government, the decree shall declare the rights of the several parties interested in the property, but shall direct such partition or separation to be made by the collector or any gazetted subordinate of the collector deputed by him in this behalf, in accordance with such declaration and with the provisions of section 54. And in fact, lordship, Assam Land Revenue
Yes,
also
yes.
says deputy collector,
Yes,
lordship.
correct.
So, lordship, on the very first date, we have filed an adjournment application saying that our engaged counsel is going for House lordship. So an adjournment petition was filed that was allowed, and on that day, lordship, 27/7/22, the decree holder filed an application for survey, lordship. The learned executing court said that we have received the petition without any objection. In fact, lordship, on that day, we have filed an adjournment petition, lordship. That also I have enclosed with this application, lordship.
Now, what is the stage now here in this case? What order is,
After
is there any
issuing,
interim order passed?
yes,
Yes,
lordship.
Yeah,
Execution
yes.
has state, lordship.
So,
Yes,
my lord,
Mr. Kadir, what, how do you gain by this stay?
my lord, the subject matter is a, my lord, betel nut garden. The whole land is, my lord, betel nut grown by the plaintiffs, my lord. And they are enjoying the fruits, my lord. Every year they sell the whole,
No, isn't it an estate? It's an estate. There is no manner of doubt.
my
That
lord.
the subject property is an estate.
Yes, my lord.
And both the provisions of section 54 and as rightly pointed out, order 20 rule 18 would come into operation, which has specified that these are will come within the domain of the collector now or his designated officer. Now, having somebody else engaged, she per se is not objecting to the execution. The objection is only with regard to the procedure adopted by the executing court. Why don't you come to a consensus that that the proper procedure be adopted?
My lord,
Ultimately, you are not gaining anything by this stay order.
my lord, because my lord, the fruit of the, my lord, fruit, my lord, is stayed, my lord. I cannot enjoy, my lord, for the during
That is
the,
what we are exactly saying.
Yes.
Stay is not benefiting you. Stay is against you.
against me. Yes, my lord.
So if you take instruction that this procedure may be followed, should be done by in accordance with order 20 rule 18 and section 54. Matter ends there.
My lord, what my humble submission, my lord, my learned friends, my lord, regarding section 54, it is, my lord, regarding the partition suit. It is not a partition suit, my lord.
What is this suit for?
My suit for right and interest, my lord, and possession, my lord. What the section 54, my lord, it is regarding, my lord, partition suit, my lord. May I read, my lord, 64,
No,
my
no,
lord,
yes, yes, yes.
and
This
20
is
also,
suit
my
for
lord.
this suit is not for partition.
Not for partition, my lord. Right and interest, my lord, my
Yes,
suit.
yes.
So these provisions are not
Where is
applicable.
the plain?
Yes, my lord. Plaintiff is not, my lord, the judgment is there, my lord, page number 17. Page number 17.
Then the direction may be seen, lordship, the paragraph
Page number
29.
17, my lord. The suit is for declaration of right title and interest, my lord.
Madam, this is not a partition suit.
But the direction, lordship, in the
No,
light of,
direction is different. Partition suit is that's
Lordship,
totally different.
no,
There is a
lordship,
preliminary decree, there is a final decree.
it's a
It is only
preliminary.
because of those purpose that the role of collector comes in.
Yes, my lord.
No, lordship, may kindly read the paragraph 29 of the decree, lordship, of the judgment, lordship, page
Page
32.
30.
32, lordship. In the light of evidence on record of both sides along with exhibits beside discussions on foregoing issues along with reasons, I have reasonable ground to consider that there is valid link of title of plaintiff from original owner, namely Akmat Ali. In the light of above stated discussions, it has appeared that corroborations of witnesses of plaintiff have amplified the trustworthiness of witnesses of plaintiff against the witnesses of defense. Inference of preponderance of probability can be drawn from the material on record and also by reference to the facts having the high degree.
We'll come back. 2
Lordship.
o'clock. But we will rise early at 3 o'clock. We have some administrative work today and tomorrow. But we thought it was a partition suit.
And my lord, the grounds, my lord, 10th item, all the grounds are for appeal, my lord.
Two matters is a lordship is rising early. Item 24 may kindly be taken. We are respondent for in that matter.
There are many other councils. All matters are important.
Lordship
We
counsel.
cannot give preference.
Lord-
Yes, what do you say?
Lordship.
How do you react?
Regarding judgment, lordship, there is a specific order that demarcation is to be done by the competent government authority, lordship. Page 32, para 29, lordship.
But it's a consequential thing. The
Lordship.
suit is not for partition. The provision of law,
Right title interest along with eviction of the defendants, lordship.
not a partition suit.
Lordship. But lordship, regarding
For
measurement of the
applicability of
land,
54 or order 20 rule 18. It has
lordship.
to be connected with a partition suit.
But lordship, the competent authority is the revenue authority, lordship. Their head of the lordship, the deputy collector is to be appointed, lordship. May I read the para 29, lordship?
We have read.
Lordship. And there is a specific direction that if in the demarcation process, the plaintiff are found dispossessed, lordship, then they may be placed on the put
I
into
don't think it's
position,
a,
lordship.
it's an execution objection. At this
Lordship.
stage,
And lordship, from the order itself, it reflects that lordship in the execution petition, they have prayed for injunction, compensation and all these things. These were not granted by the trial court, lordship.
we'll not go behind the decree now.
So
Decree
there-
has been passed. You have
And not
accepted
only
the
one
decree.
objection, lordship, I
You have
have some
accepted the
other
decree. You have
objections.
not filed any appeal.
No, appeal file, lordship, that I have certified.
Pursue
copy.
your appeal.
Lordship.
If the appeal has been filed, you said there was zero condemnation.
Yes, lordship, there are
Pursue your
360
appeal. Now, at this
days.
stage,
lordship.
they are not going to. Pray for an interim order from the appellate court.
Stay was also filed, lordship, along with the first appellate
It's
judgment,
for the
lordship.
appellate court. Now, at this stage, on this ground, we are not.
Not only that objection, lordship, my objection petition contains some other grounds also that, lordship, their execution is,
We are dismissing.
lordship.
Art Chaudhary, Senate counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India, paired with Section 151 of the CPC. The petitioner, who is the defendant in the suit, has challenged an order dated 22/9/2022, passed in title execution case number 8 of 2020, whereby the learned civil judge Hailakan has rejected the objection raised by the petitioner within bracket judgment letter bracket close against the maintainability of the execution petition. Full stop. The petitioner has also challenged, has also brought to the notice of this court an order dated 27/7/2022, passed by the state court in allowing petition number 277 of 2015 filed by the decree holder with a prayer to direct survey of the decreed land through Amin Commission. The suit was instituted against the defendant for declaration of right, title, interest, and for recovery. Full stop. The suit was decreed on contest on 28/2/2020. The MS Chaudhary, the learned counsel, has submitted that in the meantime, an appeal has been preferred, which, however, was barred by limitation, and accordingly, the state appeal is accompanied by an application for condonation of delay. Full stop. The principal ground urged in this petition against the order passed by the learned executing court is that the state executing court failed to appreciate the provisions of law which are the provisions of law. In this connection, the learned counsel MS Chaudhary for the petitioner has referred to section 54 read with order 20 rule 18 of the CPC. Full stop. Section 54 is with regard to partition of estate or separation of share, whereby wherein it talks about the procedure in case of a decree for partition of an undivided estate. Full stop. Order 20, Rule 18. Is in connection with section 54. Full stop. For the sake of convenience, both the aforesaid provisions of law are expected herein below. It is the submission of the learned counsel for the petitioner that such procedure has to be done by the collector or any gazetted subordinate officer of the collector deputed by him, which, however, has not been followed in the instant execution proceeding, and therefore the impugned order dated 22/9/2022 is not sustainable in law and liable to be interfered with. Full stop. The learned counsel further submits that the order passed in the petition by the decree holder on 27/7/2022 is also in violation of the aforesaid provision of law, as ultimately the question of partition would come in. Full stop. For contra, Sri M.J. Katil, learned counsel, as learned counsel for the respondent numbers, all the respondents. For the respondent,
But I will refer rule 4 of the revenue regulation, specifically mentioned that
has submitted that there is a basic fallacy in the argument and projection made on behalf of the petition. Full stop. He submits that though there is no dispute to the proposition that it is section 54 and order 20, rule 18 of the CPC, which would apply in a suit for partition, comma, the point which is to be noted in this case is that the instance suit is not for partition and is a suit for declaration of right, title, interest, and recovery of possession, which was decreed on 28 to 2020. Full stop. He also questions, he has also relied upon
Well, rule 4 of the under the land revenue regulation matter. Rule 4.
rule for
Yes.
regulation.
Regulation matter. Rule 4 under the regulation. Settlement officer, he has the power of the deputy commissioner.
The learned counsel has also referred to the rules framed under the land and revenue regulation under chapter 1, section 1, full stop. Under rule 4, settlement officer has been under rule 4, the provisions has been laid down that when a settlement officer has been appointed under the regulation, comma, he shall exercise the power of a deputy commissioner as conferred by this rule. Full stop. The learned counsel for the respondent, according to submit, further submit that the conduct of the petitioner in filing the present in taking recourse of filing an objection in the execution proceeding, as well as a parallel proceeding by filing an appeal will itself demonstrate the lack of bona fide, as the appeal was not preferred with due diligence and there has been a delay, which is yet to be condoned.
Lordship, the appeal was filed later on, Lordship. After filing the
Yes, doesn't matter.
CFP, Lord,
After after consideration of the submissions made by the rival parties and on perusal of the materials on record, this court finds forth its submission made by Sri Kadir, learned counsel for the petition, respondent, that the principal grounds of challenge by taking the recourse of section 54, read with order 20, rule 18 of the CPC, will not be available to the petitioner, as the suit in question was not a partition suit, and admittedly the suit was for declaration of right, title, interest, and recovery of possession. In view of the above, this court further, the scope of a revisional court is limited, and such powers of revision would be exercised only when only on restricted grounds. In view of the above, this court is of the opinion that the instant petition is misconceived and according the same is dismissed. Full stop. Interim order passed at 10 vacate.
Sure. Item number 18, only numbers are different. Title, suit and lordship.
18.
Yes, lordship.
18 step. Position is the same.
Same
Title,
position, same order, my lord.
no, lordship respondent name is also different.
No, we are not on the names. The position.
Execution case.
One
position
respondent.
is same.
One respondent.
Lordship.
Different respondent, my lord.
Execution.
Different
case
respondent, the same.
Understood.
Yes.
Position is very
Same, my lord, same. order.
Execution number, title execution case number will be lordship 07-2020.
Zero.
And
And
first
title
one,
suit?
title suit lordship, that is
Ground of rejection.
4/16.
And even here, two orders were there.
Yes, lordship.
Yes. Same
One
day.
for Amin Commissioner, one for
Lordship. Same,
Order
same
date-
only, the
date of the
title-
orders are same.
same lordship, 22/9.
Title suit is different.
Suit number different.
Suit and the title execution case is different.
First one
Petition-
is,
How many petitioners are there? Only one or many?
no lordship, petitioner same lordship. Their predecessor was dependent, later on all the legal heirs.
And respondent?
One respondent.
One. Okay. Okay.
In both
Yes.
the cases, there are, my lord, interim order. Of like.
Nine. That's your state. Oh, yes. What is your feedback?
Lordship, feedback, I did not get any feedback, Lordship.
No feedback.
No feedback. I think there is some urgency in the matter because this matter has been fixed on day after tomorrow for final.
No, you can have it tomorrow. Call up your colleague.
Because otherwise it's not going to affect in any way, Lordship, because this is the previous judgment which has set aside that
No,
order.
no, if you are involved, we will not take it up. But we don't remember anything. And since there is a possibility of somebody else being there,
Maybe, Lordship, maybe.
have it tomorrow. Get talk with your colleague on the pair of the SP Chaudhary. When it comes for the petitioner, please take it tomorrow.
Obliged, Lordship.
For case to various and computer type মানে order to যদি ওলাই মোৰ লগত কোন আছে সেইটো কম
My lord, this item is relating to the ex parte judgment and decree for eviction, my lord. And LCR has come. Your lordship may kindly see the LCR. Because some dates are very important.
Just a minute. I'm just having a look at the parties.
The notice was served, but
No, looking at the parties. Connected to Ritura's hotel. Respondent connected to Ritura's hotel over.
my lord,
Who's the respondent?
Bhavesh Chandra Barua.
That is it. Who is it? Is he connected to this hotel, Ritura's hotel?
Not, perhaps.
Not.
Yes.
Is it for any other?
Much.
My pleasure, Lordship. My lord, this is a regular first appeal. The appellants before Lordship was where the my lord plaintiff, the suit has been dismissed. And there is
Dismissed
no,
on what, though?
my lord,
On merit?
on merit, my lord. I don't have any prayer for stay also, my.
You're the plaintiff. What stay will you have?
I don't need any stay. I don't have.
How can you have a stay order?
I cannot have.
You can pay for injunction.
No, my lord. There is no scope of injunction. Also.
Third, Sri M.K. Chaudhary and the Senior Constitution, assisted by Sri P. Bharadwaj. The instant appeal is preferred against a judgment and decree dated 4/3/2023, passed in title suit number 27 of 2016 by the learned civil judge, Lakhimpur. Full stop. By the aforesaid judgment, the suit has been dismissed. Full stop. Admit.
In fact, my lord, there was a counterclaim. There were two counterclaims. One counterclaim has been allowed, another counterclaim has been dismissed.
Are you challenging the?
No, my. The entire judgment I am challenging.
Admit. Para. Admit. Call for the record. Para. That steps for service of notice upon the respondent be taken by usual process as well as by registered post with AD. Steps within a week. List after 6 weeks, along with report on service as well as LCR.
I love it.
Yeah, please. My lord, this appeal has been preferred against the order passed by the Railway Claims Tribunal Guwahati Bench. My lord, we have applied for only modification of the award. Award has been given by the RCT, but the mode of payment, my lord. Your lordship will find the
only 50,000.
My lord.
Only 50,000.
Yes, my lord, only.
And
Only 60,000 has been released. My lord, 8 lakhs has been awarded.
Why is this going on?
Father and mother.
Lordship, actually, it's on the basis of Delhi High Court judgment, and thereafter a notification is also there, Lordship, on the basis of that Lordship
If you
notification.
do not give a substantial amount at the beginning, what is the use and objective? Will they survive for 3 years, 4 years?
And Lordship, many cases, some complaints are also there regarding who had actually received those.
That is a different matter. You have to tackle that problem. This is not a solution to that problem.
Lordship had
Out of 8 lakh users deposit, asked to deposit 60 plus 60. In case one case we have found 51 lakh.
I mean,
we understand that half you can give for FD. You're doing not even 25%, 20%.
But they are old, my lord. Father is 62, mother is 53, old age.
And regarding authenticity, you may have a very good point, but this is not a solution. That whether there may be some apprehension of abuse, that you have to sort out in the trial court itself, the tribunal itself.
In fact, Lordship, in this case, Lordship, 11 lakhs, 17,984 rupees has been sanctioned, Lordship. But you, as per this RCT's order, Lordship, you will get what? If Lordship modified that, that's a part.
We'll modify this.
Lordship, one judgment has Lordship passed, in fact. Yes. Similar case, Lordship.
We have annexed.
That is another court. Lordship judgment is MFA 50 of 2023, 19.
We'll follow that.
Lordship.
I think that 50,000 was.
Lordship,
in that case, 50 out of 4 lakh.
2 lakhs Lordship is shall be released. Yes, and
Yes,
the
50
remaining,
is
yes,
yours,
remaining is in.
Here we'll pass the same order. Can you spare a copy?
Lordship, this is annexed to it, my another petition, Lordship.
We'll have a copy.
50 of 2023, MFA.
Here it was there were two claimants.
Two claimants, father and mother.
Okay, 4 lakhs each was granted and 60,000 was directed to be released. We'll make it. How much did we pay? 2 lakhs.
2 lakhs.
And rest 2 lakhs.
Lordship
with
judgment
interest,
says that. Yes,
with interest as FD.
Lordship.
With same order. J. Mullah and B. Sharma. Here for the railway or the CGC?
CGC.
CGC appearing for the railways. Yes, we have.
My lord, one judgment,
Who-
we
who-
have annexed. We have annexed one judgment,
Who passed away?
annexer B,
Who passed away? in your case?
Son of
son.
When was the,
Father and mother are the claimants,
yes, yes.
son died.
1750.
Disposed of.
Okay. It is your lordship. Lordship, this appeal is filed under section 30 of the Employees Compensation Act. And the substantial question of law, lordship, I mentioned at page 8.
Eight.
8, lordship. 3 substantial question of law. What we are saying that the injured was not employed by the owner of the vehicle.
There is no employer-employee relationship.
No, that is it. And no premium was paid here. He was a gratuitous passenger, and he himself in evidence adduced, he said that he was paid by the person for whom the material were taken. The person in the material were carried in the truck, and he was paid by the person who had taken the material.
You're the insurance company.
Yes,
aren't you?
lordship.
And who was the employer?
Employer will be, as per their own evidence, will be the person, lordship, in a.
Who was the employer? What is the manufacturing unit?
No. It was a vehicle, lordship.
Understood. Employer.
Employer, he's here. Employer is, that name has not come, lordship. But what he said is he was paid by the person who had.
We are not asking.
Huh.
He claims to have been working somewhere, isn't it?
Or with Gopal Singh in the vehicle.
Understood. What was he doing? What was Gopal Singh doing? It's a manufacturing unit or what?
No. He in his truck, some materials were taken from one destination to another destination. The destination where the materials were unloaded, there the person who had ordered those materials to be taken in the vehicle, he had paid him. So there is no employer-employee relation between the.
The vehicle is in the name of Gulab Singh.
Gopal Singh.
Gulab. You've written Gulab in ground one.
Ground one, he said Gulab Singh. That is what his employer was, Gulab Singh, and the owner of the vehicle is Gopal Singh, lordship. And then also we have mentioned in his examination itself, in his.
How much is the amount?
Amount is, lordship, 1 lakh.
1,20,000.
Yes, 1,20,000 with 9% in.
What is the requirement nowadays of deposit?
Deposit for WC Act, lordship. Our own High Court has passed the judgment quite some time back, and this is followed by Apex Court also. We don't need to deposit, unlike MSC cases. Lordship, I'm giving this.
What about the statutory requirement?
That is what, lordship, it is not required in MV Act. What was discussed in this judgment was, lordship, section 30, that if only the owner files the appeal, then he has to deposit. Otherwise, insurance company.
But you step into the shoes of the owner.
No, that is what in the judgment, lordship. We do not step into the shoes of the owner. I'll give the judgment, lordship. Relevant para will be 46, 47, 48, lordship.
We'll do one thing. We'll have it this tomorrow or day after. You just pass on the judgment.
Yes. Let it be on day after, lordship.
Third MS RD Mazumdar. Then it comes for the appeal. Let this appeal be listed for consideration on Friday. I am retaining this.
Yes, lordship. Highly obliged.
Which paragraph?
46, 47.
There are Supreme Court of Supreme Court is there. We have discussed this point somewhere.
It started with this judgment of our High Court, lordship.
Because section 30 has been elaborately been discussed. You will look into.
Yes, lord. Highly obliged.
Yes, Jacob, what is this?
This revision is directed against an appellate order, my lord. Initially, we had filed a suit for partition. Injunction was granted ad interim. It was made absolute. Against that, they preferred an appeal. And in the appeal, the order of injunction was set aside, which is why we are here under 227. my lord.
In a partition suit.
In a partition.
The injunction was vacated in the
By
appeal.
the appellate.
Okay.
Now, my lord, if your lordship takes up the memo, my lord, I'm sorry, the petition, the suit was for partition, my lord. It is just to indicate the relationship between the parties. If I may just hand over a concise points of argument, I'll refer to that later, but just to indicate the genealogy.
You are the plaintiff.
I'm the plaintiff.
Suit for partition.
Suit for partition.
Declaration of right title and interest, partition and injunction.
Declaration is also there.
Declaration is there.
Okay.
Now, the property involved was admittedly owned by two brothers. They are Hatturam Malakar and Huhiram Malakar.
Owners.
Owners, my lord. Now, the parties to the suit are the descendants of Hatturam Malakar. If your lordship takes up page 2 of that note, my lord, I've indicated the genealogy. Okay. So Hatturam Malakar, my lord, he's the original owner. He had two sons, Rotneswar and Gobindo. Now, Rotneswar had 5 sons, and number 3 and 4, Nitya and Gita, are plaintiff 3 and 4. And on sons of legal heirs of Gobindo, your lordship finds Purnima and Ujjwal, they are plaintiff 1 and 2. So some cousins have sided together.
Okay. No, okay. Doesn't matter. Then what are the...
Now, our suit was simple, my lord. Since Rotneswar and Gobindo were the original owners, all his legal heirs should get equal share. This is our basic premise for claiming partition. Now, we say that out of, we discovered that defendant number 1, who is also the respondent, she had surreptitiously got her name mutated exclusively, depriving her cousins as well as her brother and sister, and she started construction of a building, which is why we approached the court for an injunction.
You say that the land was yet to be partitioned.
Yet to be partitioned. Now, my lord, I'll just indicate the defense of the.
What was the source of the mutation change?
Well, they had filed an application that we discovered pretty late when they filed their written statement. They say that Rotneswar Malakar had sold the entire plot of by virtue of a registered deed in favor of his daughter, who is the defendant number 1.
Registered deed.
Registered deed. Okay. Now, their defense, if I may just point out page 38 of the petition, my lord. So they had to deny the title of the cousins, that is the sons of Gobindo, and they had to deny their the title of all.
This registered still did was in the name of
Rita Malakar.
Defendant number 1.
Defendant number 1.
Okay.
So she basically claims that the entire property is hers.
Okay.
Now, to say that sons of Gobindo did not have title, she sets up a plea that there was a partition between an amicable division between Rotneswar and Gobindo, and Gobindo had taken a share elsewhere in a different Dagen Patta. That is how
kind of family arrangement.
Family arrangement. That is their plea, and that is how they say that the sons of Gobindo are not entitled to a share. And insofar as her own brother and sister is concerned, she says, "No, my father sold the entire property to us." So in this manner, she tries to dislodge the inheritance of all the others.
So far as Gobindo's ancestors are legal heirs are concerned, Gobindo had taken another share from Ratneswar, so they are not there. And own brothers, there is a sale deed.
There is a sale deed. That is their plea. Now, my lord, the trial court heard the matter and eventually said that this requires adjudication, and therefore it made the order of injunction.
Let us see the order of injunction.
At page 91, your lordship find. Relevant portion begins at page 93. That is where the discussion is.
And
93. The third paragraph, my lord. From the above discussion, it appears that the petitioner plaintiff is having a prima facie right and enjoyment of the suit land as the property is a joint property and dispute regarding a plot of land where both parties are claiming right title and interest. Since the main issue has not been decided yet as to who is the rightful owner of the suit premises, and as the matter is already in the court, such act alleged to have been committed by the defendant petitioner is likely to damage the disputed property. Only a prima facie case in favor of the plaintiffs alone does not entitle them to a temporary
So the injunction was given not to change the nature and character of the
suit land.
What was the first appellate court?
Now, first appellate court's judgment, your lordship finds at page 107, my lord, and 117 onwards is the discussion. 117. If I'm allowed to read this paragraph.
Yes.
Just two paragraphs of it, 10 and 11.
What was the date of the injunction?
That was 22/3/22, 22nd March.
22.
Yes.
Then at this order?
This is 2/5/23, like 2nd of May.
2/5/23. Appellate court.
Yes.
Okay. Appeal has been allowed.
Appeal has been allowed. Lord, I just skipped one portion, my lord. Along with the written statement, they also filed a counterclaim, saying that we have a sale deed, therefore our title should be declared and we should be evicted. Now at para 10 of that judgment, my lord,
page
117.
Yes. Yes, please.
In the injunction case, the learned trial court held. Now let's discuss the materials on record and try to arrive at the definite finding as regards the three requisites for grant of temporary injunction. The OPs admitted to the fact the property was a joint property and they have mutated their names. But it is settled law the entries in the Jamabandi are not proof of title and only for the statement for revenue purpose. On arriving at such a decision, the learned trial court failed to appreciate the fact that the defendant appellant relied on a registered sale deed being deed number so-and-so, executed by Rotneswar Malakar in favor of Rita Malakar, the appellant number 1. It is the law of the land that presumption should be in favor of a registered document unless and until it is rebutted. On perusal of the registered sale deed number so-and-so, it is evident that the Schedule V property mentioned in the plain was sold by late Rotneswar Malakar in favor of Rita Malakar. On the basis of the said sale deed, the name of Rita Malakar was mutated in the Jamabandi. It is interesting to note that one of the plaintiffs, Nitya Malakar, signed as a witness on the said sale deed. The plaintiff respondents in the plaint have not prayed for cancellation of the said sale deed. In this regard, learned counsel
What about your counterclaim?
No, counterclaim, they had lodged. They had lodged. In this regard, learned counsel for the appellant has relied on the following judgment. Reported in so-and-so, the Honorable Apex Court observed that it is equally settled law that injunction should not be issued against a true owner. Therefore, the courts below have rightly rejected the relief of declaration and injunction in favor of the petitioners who have no interest in the property. Even assuming they had possession, their possession is wholly unlawful of a trespasser, and an injunction cannot be issued in favor of a person who gained unlawful possession as against the owner. Pretext of dispute of identity of the land should not be an excuse to claim injunction against the true owner. It is admitted by the appellant in the instant case that the appellant allowed the plaintiff number 3 and 4 to reside over the Schedule B property on humanitarian ground. In this regard, the learned counsel for the appellant has relied on the following judgment. I'll skip that, my lord. And at page 119, your lordship finds paragraph 11. Now, if we analyze the present case in view of the above discussion, it is evident that the appellant was possessing the Schedule B land after the execution of a registered sale deed in the year 2002. Now she is developing the suit land after taking loan from financial institution. The plaintiffs filed the suit after a long time of execution of the registered sale deed without challenging the said sale deed in the plaint. The appellant is in possession of the Schedule B land, and the plaintiff number 3 and 4 was allowed to stay in the said land. Hence, I am of the considered opinion that the plaintiff respondents do not have any prima facie case against the defendant appellants regarding the Schedule B property. Moreover, the balance of convenience is not in favor of the respondents, and they are not going to suffer irreparable loss and injury if the injunction is not granted in respect of the Schedule B land. From the above discussion, it is clear that the order of the trial court is perverse, illegal, and against the established principles of law for granting temporary injunction. Now, my lord, if I have understood the order correctly, my lord, the first ground for reversing the judgment was that there is a registered sale deed. On the basis of this registered sale deed, the learned appellate court goes on to say that now, since there is a registered sale deed, my status is only that of a trespasser. Thirdly, it takes note of the fact that there is no direct challenge to that particular sale deed. And fourthly, there's also a passing observation that one of the plaintiffs was an attesting witness to the deed. So the entire finding is basically based on the fact that there was a registered sale deed by Rotneswar Malakar in favor of his own daughter, and therefore all others have been sort of taken away from the normal line of succession. Now, my lord, to that, my lord, the first thing I'd like to argue is that insofar as antecedent title of Rotneswar and Gobindo Malakar is concerned, that is admitted.
Mr. Chaudhary, what kind of change are you bringing? Construction?
My lord.
You are not parting with this. Are you parting?
No, not at all. We are constructing, my lord. The suit came when three
we'll
stories
come
of
to
the building was, my lord, already
We'll come.
constructed. And I'll say, my lord, let him finish.
So, my lord, antecedent title of Rotneswar or Gobindo are admitted, my lord. Only defense is Gobindo gave up his share, relinquished his share, and he took some share elsewhere. Now, to that, there is no document. There's only a statement to that effect. And there is no document of family arrangement, nothing. Now, the trial court had observed that this will...
But Schedule B is the land which is a part of the sale deed.
Yes, ma'am. I'll come to that.
We are on the Schedule B only.
Yes, ma'am. Schedule B only. Now, they say Gobindo had relinquished his share and parted from possession. Now, to that, since it's a case of oral arrangement, the trial court has observed that this will require evidence because they don't have any document. Now, the Gobindo, insofar as Gobindo Malakar is concerned, my lord, the appellate court does not really endorse that statement made by them that there was a division between Gobindo and Rotneswar. Now, if there is no division between Gobindo and Rotneswar, Rotneswar cannot have absolute title or saleable interest in respect of the Schedule B property.
Unless that is a subject matter of challenge.
I'll come to that again. Now, that is the second point which I'll argue, my lord. Now, it is a tried position that one has to transfer the best title which he himself has.
We'll consider this submission if you raise this issue. You have not raised this
I've raised this issue by way of an amendment, my lord. Because our cases, when they filed the written statement, we filed the objection because they had also filed an application for vacating. Then we filed the objection and we stated that this sale deed was never in our knowledge, and thereafter now an application for amendment is pending.
Now, has it been allowed?
That has not been allowed, and my argument is I need not challenge that sale deed. And there's a Supreme Court authority to that effect.
Those will be matters of adjudication.
Exactly, precisely my point, my lord. Those are matters of adjudication.
Normally, yes, injunction matters, appellate court needs to go slow.
Yes, my lord.
That is, but here there is a sale deed. Registered. And we have seen that the injunction is only limited to the point that will not change the nature and character. That was the injunction. There is no, while vacating the injunction, we have asked him, he is not going to part with the land.
He has made a statement that he is not being able to deal with the property because of the injunction order.
Exactly. Is he parting with the third party?
That is his intention, and he is...
No, we will ask him, is third party rights being created?
Two, three things, your lordship will kindly allow me to press, my lord.
No, we'll definitely hear you, but at this stage,
My lord.
with this position, are you going to create third-party interest?
No, my lord.
They have in fact already done that, my lord. I'll show it from the record.
Show us.
My lord, first of all, they have already made a statement that we want to, my lord, deal with the property. We are not being able to deal with the property because there is an injunction that,
Dealing is a very vague term.
my lord.
Dealing means he may want to build something about it. He may want to develop it.
We are, my lord, constructing a commercial building, my lord. They are taking, my lord, loans from financial institution. And because that is a, my lord, prime property, my lord, in the heart of Haju town. What we are contemplating is giving it on rent, my lord.
And what happens to me, my lord, they have also issued a notice for my eviction. Now, my lord, the thing is, my lord, they are saying that because of the order passed by this honorable court, they have been suffering losses and 3 stories have already been constructed. That is their stand. Now, my lord, this stand was not there before the trial court, and injunction was not for the first time passed by this honorable court. Injunction is operating from 21. So the question arises, when did you make the constructions? Did you make the constructions in the teeth of the order of injunction? Because injunction was vacated only for a month.
No, you said that the order of injunction is 22.
No, my lord, there was an ad interim operating, my lord. There was an ad interim order of injunction operating since 2021. That was subsequently made absolute in 2022. And that was in March 2022. My lord,
When was the ad interim passed?
ad interim was passed. Your lordship will find it at page 81, 1321. 1321, the ad interim order of injunction was passed, my lord. 2322, it was made.
Let's see the objection to the injunction petition. Have you done it?
Yes, yes, my lord. My lord finds that at page 70. I'm sorry, my lord. 56, my lord.
It's 50?
6.
Yes.
My lord, page 57 is what their basic case is, my lord.
57.
57, my lord. Subpara of para 5. My lord, the moot question is, my lord, prima facie, the sale deed, how can it operate, my lord? He is entitled to only half his share along with his brother. How can he sell the entire plot of land in favor of his own daughter?
Dekha, we are not saying that these are points which does not really require consideration, but it has to be considered in an appropriate manner when you raise this issue. Unless the sale deed is challenged, why, under what circumstances was made, we cannot go on presumption.
Well,
it is a registered sale deed. You may have good grounds to set it aside, but you have to challenge it.
My lord will kindly consider.
Can we go by presumption vis-a-vis a sale deed which is registered? No, it could not have been. Might have been. You may be correct, but the document exists.
My lord, one judgment, 2 paragraphs of a judgment, my lord. I'll just.
Now let us see the.
My lord, the
as far as
objection.
Your objection is concerned, you have said that it's operating since 2021.
Yes, my lord.
When did the building come up?
Yes, my lord.
Was it averred in this?
It is averred in the affidavit of in opposition filed in this case. That
No, in the objection.
In the objection, they have vaguely said that we have started construction of a building.
Let us see where.
My lord, page 56, if your lordship takes up. Page 61, I'm sorry.
61.
The subpara again, my lord. In this respect, the OPs state that after.
What is the stage of your building, Mr. Chaudhary?
My lord, it is, there are some photographs given. In the affidavit in opposition, my lord, we have given the photographs, my lord. In fact, my lord,
what is the stage?
My lord, three, my lord, stories have been completed, my lord.
And my lord, we are also living there, my lord, without any windows and all, my lord, now that injunction has come.
Photographs are here.
Yes, my lord.
Page 138 of their affidavit in opposition.
Yes, my lord. Yes,
Have seen.
yes, ma'am. And in the top floor, Lord, you will see, my lord, even we have not, my lord, been able to, my lord, because of this injunction, we have not been able to, my lord, fix our windows or also, my lord, and we are living there like that, my lord, with a family.
Are you residing in this house?
Yes, my lord. Rita Malaka resides there, my lord, along with her son, her daughter-in-law, and with a 6-month-old baby, my lord.
We may have to continue it tomorrow. We will have to rise at least. There's some recruitment process. We'll have this as first item tomorrow. First item.
My lord,
Make a mention, we'll,
my lord. In the meanwhile, my lord, if the lordship can, my lord, get the scanned copies of all the documents which we had filed there, because those have not been annexed here. The, my lord, annexures which we.
No,
Which
let
we
us
have given.
first
Yes,
think
my lord.
whether
Yes,
what
my
order to pass.
Yes, ma'am.
Thereafter, we may.
Yes,
think
ma'am.
of-
Yes.
Have you stated about your bank loans? Where?
Yes, in the pleadings, my lord. Even in the written statement as well as in the objection filed against the grant of injunction.
We'll have it tomorrow.
My lord.
Positive time. Did not permit the company to take. As per three decades, the Learned Counsel for the petitioner has however expressed urgency. Also heard each of the Learned Counsel for the respondent. List for consideration tomorrow.
Apply.
The intent to continue until tomorrow.
Is it interim?
And there's an
Until tomorrow, until
Interim-
tomorrow. My lord, it's all right. We are not
Master
going to do anything.
then extended till the next day.
Obliged.
Others may not be possible.
My lord, your lordship, this can be taken care of tomorrow one admission matter.
State will give if the urgency is there. Any matter where interim order is there.
Item 44, your lordship.
Interim order is there. 44 positive.
I am for the respondent.
On me.
Item 45, I am for the respondent.
We're just passing the order. Next week, three more.
Day after tomorrow may be taken up my item, admission matter. Day after tomorrow. Test matter. Test matter, it's a test matter.
Best matter, we'll have it after.
My lord.
Anything?